Rove Galergaji and Kushta Planana de Viabron. You're all very welcome to the April Planning Committee. And just to welcome Rosemary and Aileen, who joins from DFA. They will be observing the meeting today, so you're all very welcome. So item 1 on the agenda is, sorry, just to confirm, Councillor McGrath is online, so we are quorate. 1, 2, 3, 4, 5, 6, 7. And Councillor Feely is on his way up the stairs. So we have an apology from Councillor Rennie. Any other apologies, members? Councillor Thompson? No other indications. Okay, item 2 on the agenda, declarations of interest. Any declarations, members? None indicated. Thank you, members. Item 3, to sign the minutes. I have just done that prior to the meeting, members. Thank you. Then moving on then to item 4, to consider one file for decision by the Planning Committee, paper A. So over to you, Darren. Thank you.
So, paper A, application number 1, LA10 2025-0263. Full application by the council for the construction of a new play park and a picnic area in Gorchin at the Owen Clue Community Centre. Recommendation then is to approve planning permission for the reasons listed within the report and subject to 2 conditions. So we'll just take you through, members. On the screen then you can see the site location plan then. Just looking down, the site's identified in red with additional lands in blue. I'm sure members know the location well. So that's the community centre there, and you can see then the location of the new play park is roughly where the yellow star is, adjacent to it. And then what's proposed is just a typical play park that's commonly found now. Quite a few applications come before the committee regarding these. So it's typical play park with a variety of equipment. And then there's a small picnic area. You can see the 2 picnic benches at the bottom of the slide. So just an image then of what the play park will look like. So recommendation then, members, paper A application number 1 is to approve planning permission subject to 2 conditions.
Thanks for that, Darren. Any questions or comments? Councillor McKellen, give me a second, Stephen. Go ahead, Stephen.
Yeah, thank you, Chair. Thanks, Darren. I'm happy to propose the recommendations as listed. This will be obviously a very welcome development for the people of the Gorchin area, and happy to propose the recommendations.
Thank you, Stephen. Right, Bob. And Councillor Robinson.
Thank you, Chair. Just a query. See the runoff from the play park, is that filtered in before it goes back into the streams or what? Or what happens to that water coming out of the play park? I'm just for curiosity.
So the surface water runoff will connect into the existing infrastructure that's there at the community centre, or else some of it will go into land drains into the surrounding fields. It is about 20 metres, I think, from the nearby burn or the water course, so there's no direct discharge into that.
You know, and I no problem seconding it.
Members. Okay, members, the recommendation being proposed by Councillor McCann, seconded by Councillor Robinson. All agreed? Okay, thank you, members. Moving on then to number 5 on the agenda, to consider 3 files for decision. Paper B, application number 1, dwelling and domestic garage. And that's yourself, Darren, again, please.
Yeah. So paper B then, application number 1, members, LA10 2024-0273. An outline application by Mr. McFadden for a dwelling and domestic garage. The location then is approximately 180 metres west of 28 Racopa Road in Omagh, and the recommendation is to refuse planning permission for the reasons listed within the report. Just to advise members and give you an update, following the publication of the committee reports, the agent has sent in 2 additional documents, and I'll show those on the screen in a second. The first one relates to an appeal decision in Nards and North Down for a certificate of lawfulness, where the issue related to commencement. And the second one related to a planning committee report dated the 20th of April 2021. And that As I say, I'll go through those two issues or two papers when it comes to them through the presentation. The supporting information and the two additional documents do not change the recommendation before you today, and the recommendation remains to refuse. So just to go through again, members will recall from the previous meeting, the application then is to redevelop a former site for a dwelling. So we're under policy HUU 10. And the policy says we'll support redevelopment of a former site for a dwelling where all of the following criteria are met, and it lists the 4 criteria. The policy clarification then assists in what the policy is aiming to do, and you can see there it chats about the reuse of an established site, which is already a commitment the landscape is considered to be a sustainable approach. So what's on the ground then, members? On the left, you can see a map showing the site in red. Additional lands in blue within the applicant's control. The site then, the building that's to be redeveloped is in green, a green rectangle. On the right-hand side is a flyover image, just gives you an idea of where the site is in relation to the public road. So you'll recall from the site visit, members, those that attended, you come off the existing road down the laneway, dogleg to the left, and then down towards the location of the building with the trees in along the existing laneway. So just in relation to the 4 criteria, I'll run through those quickly. So A, evidence has been submitted to demonstrate the previous residential use of the site. So the applicant has sent in the historical maps, and they show the location of an old building on the site, and that's considered to be a previous residential use. And then again, another one from 1846 to 1862. So criteria A is met. Going through criteria B then, so the site has long established boundaries defining an existing curtilage, which allows the resulting new dwelling to be integrated into the landscape. Where the size of the dwelling may be constrained by the size of the existing site, removal of established mature planting on the boundaries to facilitate the dwelling will not be permitted. So I have 3 images there, members, just to provide you with information on this. So the left-hand one is the ordnance survey map, and you can see the laneway and then the outline of the 2 or buildings, and then other outlines there. The middle one then is the site location plan. So the site is outlined in red, with the building then to be redeveloped in green. And then the image on the right-hand side is a flyover photograph showing the location of the site. So one of the issues you'll note from the report is that the size of the site is considered to be constrained by the existing hedgerows. And in cases like that, removal of established mature planting on the boundaries to facilitate the dwelling will not be permitted. So the sites on the left and the red lines, when you overlay the curtilage of the site on the right-hand side drawing, you can see the position of the existing building is a red rectangle. You then have the red line at the top of the slide and the yellow line at the bottom. And those 2 lines define the established curtilage around that existing building. So you're within that area of the blue star. So what that means in relation to the policy is that the areas with the yellow star are outside of the curtilage of the existing building. The curtilage then is the area inside the yellow rectangle, which is identified by the red star. So the issue in relation to this policy criteria is that redeveloping the site is constrained by the site boundaries, and if a new house is approved in there, it will result in the removal of the existing trees, especially along that yellow line on the left-hand image, the yellow line, which defines the curtilage there. The tree canopy overhangs almost half the site, and if a new dwelling is constructed in there, it will result in the loss of those trees, which is contrary to the policy B, criteria B. Criteria C then requires a minimum of 3 external walls which are substantially intact, or where there are 2 external walls which are substantially intact and visible from critical views from public vantage points. So you'll recall from the site visit and the previous meeting, there is a building on site. That building has been subject to works which were in breach of planning control, and there's an enforcement notice on them. So what's there before you, members, is not what the application is looking to redevelop. So the previous planning history on the site, there's been 2 appeals. In relation to the appeal against the refusal of a replacement dwelling application, in April 19, the PAC noted in their report that in paragraphs 9 and 10, that policy CTY3, which is essentially the same policy as we have now for replacement houses, requires that all minimum external walls are substantially intact. All 4 walls are currently intact, but large sections of the walls appear to have been rebuilt recently. The appellant indicated the repair work had been undertaken as parts of the wall had fallen down. While the eastern gable wall remains intact in its original state and includes a chimney, it is apparent that large portions of the front elevation, approximately 70%, the rear elevation, 70%, and almost all of the western gable wall, 90%, have been rebuilt. Paragraph 10 then says that notwithstanding the appellant's claim that only repair work had been carried out to secure the building, the works represent a significant rebuilding of the structure. These do not represent a complete rebuild. However, prior to these works being completed, all external structural walls were not substantially intact. As raised in the previous meeting, members, the decision of the PAC is an important material consideration. It's a decision by a quasi-judicial body, and it must be given significant weight. So just to go through what the decision of the Commission found was the front elevation then has been 70% rebuilt. And that's the images from inside. The gable wall then is considered to be intact and was intact. And that's just an image inside showing the gable wall. So that is one wall that is intact. The rear elevation then has been 70% rebuilt. And again, then just looking inside, you can see the degree of works to the building, so 70% rebuilt. And then the other gable wall, the western elevation, is 90% rebuilt. So in terms of our policy, members, we have the policy which allows for 3 external walls to be substantially intact, or, which is a separate test, there are 2 external walls which are substantially intact, visible from critical viewpoints, from public vantage points. So from the road, really, you're looking into the site, and the question is, can you see 2 external walls? So this is the images provided by the agent. You can see the site and is identified by the red arrow. And then again, just in relation to the opposite direction, you can see the site then identified by the red arrow. So it's a good distance off the public road. Within the supporting information provided by the agent, there are 2 figures as well. And you'll see figure 1, which states the view from the Rocolpa Road, showing that due to the former dwelling's orientation, the gable is the only elevation that can be seen. And figure 2 again says the gable is the only elevation that can be seen. So in relation to the policy criteria, the application then would be contrary to that criteria. Other information then submitted by the agent includes 2 other pieces of supporting information relating to an approval on Doon Road, which was for the redevelopment of a site. And then another one then on Ryler Road. Again, those have been reviewed and are considered to meet the policy, and there's no conflict with this application. So again, the agent then has put in the supporting information and is making the case then that the original building is the area outlined in red on the next images. So just show you that for your information. So that's one elevation. And then the other one is the gable, which is intact. The front elevation then. And the rear elevation then. So members, you'll recall from the last meeting then there was a supporting information provided from 2 builders. And the question was raised last month about whether that was before the PAC during the time of those appeals. I've reviewed as much information as we can, and I don't see any letters such as this within the appeal, background papers or anything like that. So this would be new information that has come forward. The concern that the planning office would have is that this information, this letter was key to both those appeals, was integral to the issues and the discussions at that time. So it's very surprising this wasn't put before the PAC, because it was key to the whole issue. When was it built and what did they do? So it's only come in now in March. You'll notice as well, it's just a letter. It's just signed by anybody. It's not an affidavit, and there's no other information to support it. There's no receipts or any other information, photographs or anything at all to go with this. In terms of the letter, it's dated March 25, and it says approximately September, October 17. So a significant time away. They're not even able to tell you what date they actually did the works on and be specific on that. So they're saying approximately September, October. So there's a lot of time has passed since then. In March 2025, they've been asked to say, what did you do back then? They can't remember the date they did it on, but they're able to say to that the works that were on the building when they started work on it. So So a long time has passed since then, and to be able to accurately say that 100%, 50%, 60 and 10, that's not backed or supported by any other evidence from that. So it's something really, members, it is material, it is there, but in relation to the weight that you afford to that, planning officers will consider it's not given significant weight or determining weight. In terms of the other information that was received, as I say, there was an appeal decision sent in for a certificate of lawfulness in ours in North Down, and I'm sure the agent will go through that. It relates to the issue of commencement. Again, that wouldn't change the recommendation. And the other one then on the right-hand side is a draft report that has been submitted. Relates to an application for a farm dwelling by Mr. McFadden. It's not a final report, it's a draft report, not signed by anybody, so it's before you, but it doesn't change the recommendation. So, members, just a lot of information in there. Just to conclude, really, and focus on the two issues. The first one is that the site's very small, and a new dwelling on the site will result in the loss of the landscaping. The second one then is that this, from the public road, you can't see two walls. You can only see the gable wall. You can't see any of the other ones. Even then, the Commission's decision has concluded and has set a benchmark, really, of what is lawful and what the position is. So you can see on the right-hand side, substantially intact, the east is 100, rear is 30, front is 30, and west is 10. That is the established lawful position before you today. And when you're making a decision today, members, it's based on that lawful position. If the applicant is making a case that actually the PAC decision was wrong, and the repairs that were carried out, or the works that were carried out, and the decision they came to was wrong, that needs to be explored by an alternative route and not through this application. This application isn't asking you to say whether the PAC were right or wrong. That's a different question. What you're being asked today is, what is the lawful position? Well, the lawful position is that blue box. You then have to make a decision whether you consider that to be substantially intact. So, as members, two reasons for refusal, criteria B and C.
Thanks very much, Darren. We have speaking rights. We have representation from Brenton Johns. Brenton, if you come to the speaking area there, please. Whichever you choose there, Brenton, we can get this sorted. Okay, Brenton, as you're well aware, you have 10 minutes to present to the committee. I'll just give you the nod and I'll give you an indication when there's a minute left. Okay, Brenton, so whenever you're ready, please.
Thank you, Chair. Firstly, I would re-emphasise the fact that this application is not for a replacement dwelling, but for the redevelopment of a former residential site for a dwelling. Under the Council's new plan strategies, these are two completely different policy contexts. Under the new plan strategy, replacement dwellings are dealt with under policy HOU 08, where it requires all external walls to be substantially intact, similar to the former CTY 3 under PPS 21. Excuse me. This proposal falls to be assessed under policy HOU 10 of the new strategy, and with respect to one of the criteria, I think the Council agrees that in this case it is only necessary to have two walls substantially intact when viewed from the public road. Now, this policy does not define substantially intact, so that element becomes a matter of a planning judgment. The examples of Council approvals that were assessed and approved under policy HOU 10 were presented by the applicant. Darren showed one or two of them up there. There were certain elements in those approvals that didn't fully meet planning criteria. With reference to this case, it is clear that the builder's evidence presented at last month's meeting conflicts with the PAC report in that it demonstrates by those directly involved the extent of external walling that existed before parts had to be dismantled in order to rebuild what is on the ground today. This evidence was not presented at the PAC hearing, and the builders have indicated to me that they did not receive any notice to attend that meeting. I would presume that the previous agent did not consider it necessary, or there wasn't a need to attend. In any event, clearly this evidence was not available to the Commissioner when determining that previous appeal for a replacement dwelling. The builders corroborate that prior to the original rebuilding of certain parts of the wall, The eastern gable was 100% intact. Approximately 50% of the front elevation was intact, 60% of the back elevation intact, and 10% of the western gable intact. The applicant would strongly suggest that three of the walls, or at least two, were substantially intact prior to the rebuilding. Lacking this evidence, the Commissioner could only speculate that the extent of the external walling was as detailed in their appeal determination. But on the balance of probability, however, if the builder's information had been made available at the time, then it would be very likely that the Commissioner's percentage estimation of intact external walling would have been greater. I think it was mentioned at last month's meeting that someone said if the committee were happy that the builder's information was not available at the time of that appeal, then the members could consider this as additional information in this case. We would consider that the builder's written evidence dated the 10th of March 25 that was presented last month should not be set aside and should be afforded appropriate weight in the assessment of this application. At the last meeting, a discussion ensued about the flexibility of policy when assessing planning applications. The Humpty Dumpty approach was cited by Council last month in respect of this proposal. The ruling commented that the courts must be wary of an approach whereby decision makers can live in the planning world of Humpty Dumpty, making a particular planning policy mean whatever the decision maker decides that it should mean. It goes on to say, with disregard of the intended purpose and context of the policy. In this case, the intended purpose and context of the policy is the redevelopment of a former residential site for a dwelling. Now, planners have used court rulings to justify minor deviation from planning policy in the not-so-distant past. One in particular that is relevant to this case and is shown in paper 2, page 6 of paper 2 submitted. It says that the courts have made it clear that planning policy need not be slavishly followed in all circumstances where there is good reason to do so. For example, if strict adherence to the policy would cause unacceptable damage to some other important interest and where a balance needs to be struck. In this case interpretation, I would suggest that the Council's approach to sustainable development, which is the core principle underpinning the planning system and of significant importance, would be significantly damaged in respect of its commitment to that important interest. That ruling does go on to say it is entirely lawful for the Council to choose to disapply or modify a policy. And importantly, it says what is contained in the policy which cannot be ignored is the thrust of the desired result of the policy. So both judicial findings end similarly, in that one says that the intended purpose and context of policy should not be disregarded, and the other is that the thrust of the desired result of the policy should not be ignored. In this particular case, the desired result of the policy is not for a dwelling to be replaced, but to redevelop a former residential site for a dwelling, and this is the stated policy objective of this application. Interestingly, this judicial ruling was used by planners in their recommendation to approve a dwelling on a farm application presented to the Planning Committee in April 2021. And the planners used this judicial ruling to partly justify an approval for a farm dwelling, which was coincidentally for Mr. Desi McFadden, the applicant's father. Going back to the first reason for refusal, criterion B, it states the site should have long established boundaries defining an existing curtilage, which allows the resulting new dwelling to be integrated into the landscape. It goes on where the size of the dwelling may be constrained by the size of the existing site. Removal of established mature planting on the boundaries to facilitate the dwelling will not be permitted. And planners have referred to this small site extension in the reason for refusal. In this case, the site has long established boundaries, and this is accepted by the planners. The curtilage is only shown been extended to a small degree, not because the size of the proposed dwelling may be constrained by the size of the site, but it's to accommodate a septic tank, which is 15 metres away from the dwelling, along with accompanying field drainage. The new planning policy and the strategy PU04, which deals with development relying on non-main sewage, requires consideration of the location of a septic tank and drainage, but this was not considered in the planner's assessment of the proposal. As this application is for outline permission, the planners do not know what size the proposed dwelling will be. In any event, any dwelling can be conditioned by the conditioned by the planners to a footprint within the existing curtilage by shading it in green. For some reason, without query or confirmation from me, the planners appear to have mistakenly assumed that mature planting would be removed and listed this within the refusal reason. I can categorically state that there will be no removal of existing mature vegetation. The site outlined in red could have also been reduced to satisfy the planners if they were happy to exclude the septic tank, which would have been contrary, of course, to policy PU04. However, this was never raised with me and was not an issue until I saw the reasons for refusal originally presented to the members. So we would consider this to be a fairly weak reason for refusal and consider that the proposal fully meets criterion B. So in summary, therefore, I would contend that at least 2 walls, and most likely 3, were substantially intact. It is clear that the proposal shows no disregard to the intended purpose and context of the policy as set out in the Humpty Dumpty approach, but clearly meets the thrust of the desired result of policy HOU 10, which is that the council will support the redevelopment of a former residential site for a dwelling. Thank you, Chair.
Thank you very much, Brendan. Well within the time. So now an opportunity for members' questions. Anyone any questions for Brendan? Councillor McCann, go ahead, Stephen.
Yeah, thank you, Chair, and thanks, Brendan, again for another comprehensive presentation. This has been well, I suppose, thrashed out last month as well. I'm satisfied, I suppose, about the argument about the curtilage. And just to clarify, you're confident that any new building can be accommodated without the removal of any trees. And I suppose on page, I think it was page 16 of our presentation, I know page 15 is an overview or an overview of the site. Should I get this right now? Sorry, Chair. Yeah, page 15 is an overview which shows dense population. But whenever you go to page 16, you can see that that whenever the leaves aren't on the trees, it is probably a fairly expansive site. But you're confident that any development of that site can be curtailed within that curtilage without removing trees.
Absolutely, Councillor. I mean, the planners could condition any approval to that effect, that all trees to be retained. There's no doubt that a house can be placed or located within the area where the old house would be, in and around that. There's no need to move it out of that particular siting.
Okay, and in terms of the previous application, the PAC ruling has been debated obviously last month as well in detail. But I think I've asked you this question, Brendan. You weren't the agent involved in that particular application.
No, it wasn't. No.
And that application, you mentioned in your report that it was assessed under a different policy, HOU 8. And there's
Yes, it would. The previous appeal site, is that what you're talking about?
Yeah, sorry.
Yes, that would have been assessed under the PPS 21, the CTY3 policy of PPS 21, which of course is now redundant.
Yes, okay. So it's not a fair question to ask you why a builder's report or why the builders weren't involved in that original hearing. It's not fair to ask you that question, why that didn't happen at the time, because you weren't involved.
Well, that's right, Councillor. It was just that I had to work on the basis of what I was told by the builders. I wasn't involved in the original one.
Okay. And just one last question, Chair. Do you see in terms of the D. McFadden application paper 2, we have a screen grab here of the report. Just advise Brendan why that's been included, just in your view, why that's important to this application.
Well, again, I mean, I wasn't involved with that application, but the fact that court ruling was included within the case officer's assessment means that there was maybe a slight deviation away from the policy, but it didn't impact badly on the outcome of the policy. And that's why I would put that in, because, there are various judicial findings that come out, and one was quoted at the last month, but I think it was appropriate to put this one in for this meeting.
No, okay, fair enough. Thank you, Chair. Thanks, Brad.
Okay, any further members? No further indications. Brendan, if you want to return to the seating area, thank you. That's over to yourself then, Darren, please.
Members, happy to take any questions. Just in relation to the speaking rights, so I wouldn't agree with the agent's view that there is room on this site to develop a house and not lose the trees. I'll take you back just to the image, the flyover image. The members who were at the site will recall just it is a well-treed area. I think that's that drawing there, number 15. So the site then, a site of the curtilage is important here. This is what you're looking at. The policy talks about the curtilage of the existing building. So the curtilage of the existing building is defined by the yellow line on the left-hand image, which is the tree line. And that's a mature line of, I think, are sycamore trees. So very large trees, very dense canopy, extends well out from the base of the trees. I'm sure everybody knows how mature trees can extend out from the base. So you then have the existing building then into the red rectangle. And then you have the red line then is the curtilage, which is the other line of trees. Now our site that's been applied for is shown on the left. When you overlay that onto the image on the right-hand side, you're really talking about the area inside that yellow rectangle. And when you look at that area inside the yellow rectangle, you have the trees take up half of it. You have the building taking up another quarter. So that only leaves you with the small area where the red star is to build your house. Now your development site has to be inside the red line of the application. So you're talking about putting the house, the driveway, and any patio areas, etc., all in that yellow rectangle. It's very, very difficult from planning officer's experience to see how you can build a house in there, not result in the disturbance to the tree roots and the loss of those trees. Any other site we've had, members, we keep them outside the tree canopy so they don't disturb the tree roots. If there's a house approved in there, under the canopy, the next request will be to remove the trees because of the canopy causing shading on the back of the house. And it's very difficult, if not impossible, to say no to that if an application comes in. So really the area you're looking at here that can be developed inside the red line of the existing curtilage is where the red star is. So in relation to the other issues, as I say, the builder's letter is material for members to give weight to it. And you can seek legal advice if you want on that. The position the planning officers are saying to you and advising you today is that it's the lawful position that you must make a decision on today, not something that happened back, the builders reckon, in 2017. It's what is a lawful position today. On the ground, the lawful position is the building that's there is unlawful. It's to be removed, largely removed due to enforcement notice. That will result then in the building remaining having only 100%, 30%, 30%, and 10% of the walls. So the question is whether you consider that to be substantially intact within the meaning of the policy. As I say, if the applicant doesn't agree with the PAC decision, that's for a discussion on another day outside of this application.
Councillor Irvine, go ahead, Robert.
Thanks very much, Chair Tommy. Just to clarify, I came in during the middle of the presentation, so I can't take part in the decision making, but I'm sure that's noted, but I just want to clarify it in record.
Yeah, thanks for the clarification, Robert. And John, Councillor McCloughley and Robert, you came in late, and I think Councillor Feely, you were in late. We have Rosemary and Aileen from DFA in attendance today in an observation role. Okay, members? Councillor Feely, go ahead.
Thanks. No, I was in for the start of this. I just missed the very start of the meeting, but I was in for
Oh,
all
I'm
this.
aware you were in for this one, yes.
Sorry, I thought you said
it
it
was
wasn't.
just Councillor Irvine came in a bit late on that one. Councillor McCloughley, I believe you were in in time as well.
Yeah, I was, Chair. Thank you. With that cleared up, I have a question for Darren.
Sure, that's back on track. Good man, John. Thank you.
Yeah, keep us going. Darren, we've heard the agent saying that we could put restrictions on the site to maintain the curtilage. What restrictions are we looking? Preservation orders on trees, or what would be what to what standard would we be putting restrictions, or would we be simply saying you're not to cut any trees down, which could be? I'm just looking to see how that would maybe settle my decisions, but at this stage I'm wondering just what restrictions we can put on to maintain that curtilage within in that small yellow square.
So as a standard rule for houses in the countryside, if there's boundaries to be retained, it would be done by condition. So a condition would go on saying that they have to just be retained, no lopping and topping, etc., removal, etc. But to put that condition on, it has to meet the tests of a planning condition. And in this case, it wouldn't be reasonable to put the condition on because the house is going to be right in under the canopy and it's going to result to probably disturbance to the roots of the trees, which will lead to their weakness and it probably fall. And also the canopy then overhangs half the site. So it really would be unreasonable to put that condition on because you'd be putting the house in the shade and that'll affect the immunity of residents. They'll just apply anyway to get the condition removed and it'd be very difficult for the council to say no to that. So it wouldn't be appropriate to put conditions on here. Members, if that is the sole issue, I think it's the red line of the application site that's been applied for is something that is the problem and causing the problem. And I think, as I say, due to its alignment, it doesn't really include the curtilage of the building. It leaves a bit out as you go up the laneway, etc. So that's something that we could explore if members were going to approve. We could explore with the applicant and agent and get something designed that the house could be positioned in there, but it would require a fresh application and wouldn't be within this application.
Thank you, Darren. Paul, you have a comment to make? Go ahead.
Yeah, thank you, Chair. And members, just following on from Darren's comments earlier, it was suggested by the agent during his speaking rights that if the builder's information would have been before the PAC, then that would have likely led to a different outcome. I don't think we can assume that that's the case. I've been at many Planning Appeals Commission hearings where the information that's submitted won't be taken at face value. It'll be scrutinised, and for all the reasons that Darren has went into in his presentation about the information and the substance and the other supporting information, I would suggest that it's probably likely it would be given limited weight, exactly what Darren is suggesting as part of this application. Thank you, Chair.
You, Paul. Mr. McCann, go ahead, Stephen.
Thank you, Chair. And it's just on the vein of that, that information from the builder. It is new information, I suppose, that the PAC didn't have the luxury of having. And, you know, I take on board, Paul, what you're saying, that, you know, had they've had that information, they may well have give it some weight or may not, you know, but we don't know. I suppose a big part of this for me is this application, and obviously taking on board what our officers are saying, but this application is for the redevelopment of a former site for a dwelling. This is what it is a former site. The curtilage issues, I think, aren't insurmountable. The PAC, you know, we asked for new information to be clarified whether this information was available to the PAC at the time or not, and it's came back that it wasn't. So where does that leave us in terms of a committee? You know, in terms of assessing this application on its merits, you know, the builder's letter, which I've got no reason to dispute as being accurate or anything else other than that, it would tell me that the walls prior to them being repaired were substantially intact. If you look at the figures, you know, I'm conscious that the PAC didn't have that, but it's evidence to me that would, in my mind, be sufficient to grant approval here. Maybe get a comment on that, Chair.
Okay, Philip.
So the question you're dealing with there is one of whether or not the decision that would be taken by this committee would be one which would be rational. In other words, the decision to deviate from the decision which had been taken by the PAC would be rational. There is no doubt that if you take one piece of evidence in isolation and look solely at that piece of evidence, that you can use that to support any decision that that piece of evidence purports to support. But we're in a situation here where the PAC, following an extensive hearing of the matter, which would have involved oral representations, potentially a site visit, reached a certain conclusion in relation to the matter. You have to ask yourself, would it be rational of the council to then just accept a 2-paragraph letter and use that to step away from the decision of the PAC? That's a matter ultimately for members, but when you're reaching that decision, you have to consider the matters that the court looked at in the Abelwind case, which has been referenced in the judgment. And if I might perhaps just highlight a couple of issues in relation to that. The report from Darren highlights specifically paragraph 92 of that judgment, which is specifically that point. The question there, therefore, is whether the decision maker acted rationally in deciding to depart from or reject the finding of fact. there must be a reason over and above the preference for one's own opinion to reject a finding which has been made after an investigation carried out under statutory powers. Now, I think possibly what members are asking themselves then is whether or not this piece of information in itself is sufficient to act rationally. But if you then move on to paragraph 93 of the judgment, where the judgment quotes from a Supreme Court case called Evans, the judge in that case said, in order to decide the extent to which a decision maker is bound by a conclusion reached by an adjudicative tribunal, and the PAC is an adjudicative tribunal, regard must be had to the circumstances in which the statutory scheme with which the adjudicative tribunal reached its conclusion and the decision maker carrying out its function. And this is the key part. It then goes on to say, in particular, the court will have regard to the nature of the conclusion, the status of the tribunal and the decision maker, and the procedure by which the tribunal and decision maker each reach their respective conclusions, e.g., at the extremes, adversarial, in public, with oral argument and testimony and cross-examination, or two, investigatory and private and purely on the documents. The PAC is certainly open. It certainly had oral hearings in relation to the matter, and in this situation, we simply have been presented with this piece of correspondence. Builder isn't here to assist this planning committee today, which you might potentially have expected it would be, given the nature of the fundamental nature of this particular issue in terms of the dispute. And just again, to quote from the Abowind case, and in particular then quoting from Evans, subject to being overruled by a higher court or statute, it is a basic principle that a decision of a court, PAC in this case, is binding as between the parties and cannot be ignored or set aside by anyone, including the executive. And in this case, we're stepping into the roles of the executive. So members, in order to reach a rational decision of this, it's quite a high hurdle for you to overcome in relation to that.
Thanks for that, Philip. Stephen, you're still activated. Did you wish to come in there?
Yeah, no. I hear exactly what Philip's saying, and I understand it. From a planning committee member, and then lesser as a councillor, who is obviously we're conscious of our obligations to our constituents and our rural dwellers, and this policy, you know, for example, Chair, and I invite comment maybe on a comparable note. Last month, we and this was along the lines of Humpty Dumpty language, and obviously avoiding that territory. There was an application approved here where clearly aspects of the policy was set aside to avoid going down the roads of Humpty Dumpty language. You know, this I believe is on a similar vein. Basically, what we have here is a there's no doubt about it. It's a former dwelling. The PAC ruling, a couple of points I have an issue with it. Obviously, it has a finding and it's on the record. The issue is that this policy, this application is in under HOU 10. The PAC ruled under HOU 8. PAC didn't have the benefit of the builder's letter. You know, I'm not too sure. Is the PAC, as the commissioner in that particular application, is he from a construction background? Did he have the assistance of someone from a construction background? You know, so I suppose them points made. A further question to Philip: how do I, as a planning member who is minded to approve this application, how do I reach that higher bar? You know, do we defer this application and invite a builder to come in to give a detailed analysis of his professional interpretation of the construction of the shade and what it was, or how do we get to that higher stage? I'm asking for assistance here.
Paul, perhaps go ahead, Paul.
Yeah, thank you, Chair. And maybe just before Philip comes in, I just want to clarify. I suppose you've queried the comparison there between the different policies. I don't think the assessment of the policy at the appeal stage is the material facts that's coming out of the appeal decision. It was the actual findings of what was substantially intact and what was not so much the policy. So I don't think whether the difference in the policy in HOU 8 and HOU 10 now, that to me is not material. It's the finding of facts in terms of substantial built structure. Thanks, Chair.
Thank you. And Philip, wish to come in?
I suppose, I think it's going, as I indicated when I was speaking previously, I think to reach a rational decision in relation to this matter is going to be a very hard hurdle for you to overcome. As a lawyer, if I was in this situation acting for a client in relation to the matter, I suppose one regularly finds oneself in a situation where the ruling of a higher court is not in your favour. Sometimes you just have to accept the fact that in the lower court, in this case necessary, the planning committee, you're not going to be able to get the judgment that you want, but that you have to get you have to get a decision, so as you can then take that matter on to the higher court, the PAC, in order to look at the matter again. The PAC is not bound by previous decisions of the PAC in relation to findings of fact in relation to a different matter. The PAC would be entitled, would have the opportunity of hearing those issues afresh, and looking at all evidence that was presented to the PAC, again, and additional evidence that might be available. PAC, having heard that evidence, might well reach a different conclusion. But as the agent has suggested, whenever he was giving his evidence, it's very likely that the PAC would have reached a different decision. We, as Paul has said, can't reach that same conclusion, that it's very likely that the PAC would have reached a different decision. But if that's the case, let the PAC make the decision in relation to the matter. You'd stress, however, that ultimately today, members have to make a decision in relation to the evidence that is in front of them and reach a decision which they are content is rational.
Okay, members, any further comments? Councillor McCloughery, go ahead, John, please.
Yeah. As the only ex-police officer, I suppose, in the room, I can understand where Philip's coming from, where you always have to defer to the higher court. And given the presentations we have had, I find it very difficult for us to make a decision based on what happened previously at the PAC. So I feel we have little choice but to go with the officer's recommendations and allow the agent and the applicant to take it to that court, which would be the next standard in other cases, and present that new evidence and under the new legislation. So I feel that we have to go with the officer's recommendations on this one.
Thanks for that, John. Any further comments? Councillor Mahan, go ahead, David, please.
Thank you, Chair, and listen, obviously what has been said, and I agree with Councillor McCloughery there. I think maybe the best opportunity for the applicant is a higher court, and I'm happy to second his proposal.
Okay, David. Okay, members, any further comments? We have it proposed by Councillor McCloughery, seconded by Councillor Mahan, that we go with the officer's recommendation. Are we all agreed? Okay. I need a show of hands. Is it just yourself, Councillor McCann? Okay, recorded that Councillor McCann dissent, sorry. Councillor Campbell. Go ahead, Glenn.
Check one thing before I sort of make my mind up on this. Philip in his advice mentioned that, did he mention, I just want to be clear, that it would have been expected maybe that the builder could have been present, given the significance of this correspondence. Was that something that Philip would have deemed useful in this case, beyond the letter that we have, the presence of the builder that sent the letter? I want to check that there just to see.
The more evidence that would have been available to support the agent's position in relation to this one, the easier it would have been, the easier it would be for this committee to reach a conclusion that reaching a decision different from that of the PAC would be a rational decision to make. I'm not suggesting that necessarily the presence of the builder would be determinative, because, as I say, the PAC did have a full oral hearing in relation to this matter, where people would have been available to present and deal with that matter. It's my understanding there was a full oral hearing, so I'm not suggesting that necessarily that would have been sufficient, no.
Yeah, okay, thank you. Thank you, Chair. Well, I suppose that would have been probably something I would like to have happen, but
We have to deal with what's in front of us, Glenn.
so I suppose
And
I
I
don't
had
agree with
already
the
put it to the
proposal at
committee.
present to record that, just against, Chair.
Sorry,
I would, in line with Councillor McCann here, I would sort of not be in favour of the proposal at present.
okay, you wish to record your dissent?
Very
Okay,
fair.
everyone else agreed with the proposal? Okay, thank you, members. And to sum up there, Darren, please, yeah.
So paper B application number 1, LA 10 2024-0273. The outline application by Mr. McFadden. The recommendation of officers was to refuse planning permission for the reasons listed within the report. The committee has refused the application for those reasons.
Thanks for that, Darren. Moving on then to application number 2. And that's you again, Darren, please.
So application number 2 then, members, is LA 10 2025-090, an outline application by B Keys for a single-storey dwelling and garage and lands adjacent to immediately east of 21 Glen Road in Drumquin. Members, just to advise, a request has been received from the agent requesting a deferral of the application as he is on holidays and is unable to access the meeting. He has requested speaking rights, and I don't know whether he has been able to get online and is able to attend. So he's asked for deferral. In the meantime, he's also said if he's not able to get a deferral, he has submitted a letter, a written statement, which I have before me and is included on the planning portal. And I can summarise and go through that for you, members. Yeah, is he there?
Just to confirm, David, are you online there? Didn't I?
Yes. Hello, can you hear me?
Oh, you managed to get on. Okay, Darren was just
That's it.
explaining. You
Got
weren't
on.
able to
Yes,
come on.
yes.
So just bear with us till Darren outlines the application and then I'll
Perfect.
bring you in
Thank-
at the time. Okay, David, thank you.
Thank you.
Cancel
Yeah, Darren.
that all. I'll start from the top. Paper B, application to
Rewind.
LA 10 2025-0090. So it's an application for a single-storey dwelling by B Keys and land adjacent to and immediately east of 21 Glen Road, Drumquin. Recommendation then is to refuse planning permission for the reasons listed within the report, and there are 3 reasons. So just to go through, members, you'll recall this site has been before you before. So the application then is along the public road. You can see it running sort of east-west. The application site is outlined in red. The additional lands, the circle then shows the location of the dwelling, and there's an arrow then shows the entrance into the proposed dwelling. The other buildings in nearby, so you have a property to the left in green, a property to the right in blue, and then the property beside that in red. So the aerial, or just an image then, just to get an idea of where we are and what's going on in the local area. So the site's identified with the yellow star, and that's roughly where the position of the new house would be and is proposed. Beside it is number 19, and on the opposite end of the site is number 21. You also then have another property up the road on the Drumscra Road, further to the east. Other buildings then nearby and farm buildings across the road. So the agent has submitted, a plan called the Site Design Limits, which shows a number of images and photographs taken from the site. It also includes then an overlay of the surrounding buildings, and these are circled in the black dotted line, as you can see. So I'll just go through that, members, because it is important information. So the Site Design Limits Plan includes a comment that's Policy HU 13, rounding off. The proposed dwelling is visually linked with an existing group of buildings constituting a minimum number of 4 buildings, 3 of which must be dwellings, each with their own defined curtilage. There are 6 dwellings within and surrounding the proposed site and within 180 metres of the site, and at least 8 additional buildings, garages and agricultural buildings. So just to go through that then. So this is the agent's plan As if you're in site photo 1, so you can see you're in the bottom left of the slide. You're standing on the public road looking in towards the application site from that position. That's a view then of what you'll see. So you're looking in towards the site now. That's the adjacent building then, is the sort of prefabricated tin or metal sheeting building. That building is unauthorised and is subject to an enforcement notice. That notice has not been appealed, so it is effective and requires that building to be removed. So in terms of the consideration today, it's as if that building isn't there. Another image then is up at site photo 2. So you're standing on the Drumscar Road looking back towards the application site. And again, that's the supporting image and information provided by the applicant. So you can see the number 76 Drumscar Road, and then the 2 dwellings, 17 and 21 then over on the Glen Road. Another site photo then is site photo 3, which is looking in from the Glen Road again towards the gym building. As I say, that's unauthorised, so ignore that. And you can see then looking over to number 76. Site photo 4 then is on the Glen Road again, so you're looking round and looking on the other side of the road from the application site. And that's looking at there, so you can see the gym on the right and the agricultural buildings over on the left there. Quite difficult to see, they're set back off the road, but they're at the bottom of that arrow on the left hand side. Another image then provided by the agent is site photo 5, the cross at the T-junction, sorry. And again, you're looking in at the agricultural buildings on the other side of the road, set back and accessed by the long lane. So in terms of the issues before you, members, you'll note from the report the issues that are conflict with the plan strategy. In this case, it's an application for a rounding off opportunity. The application is not an infill opportunity because there's only the 2 buildings either side, number 21 and 19, because the gym building is unauthorised. So you only have the 2, so it's not an infill opportunity. In terms then of rounding off, members, these are some of the views you can see. So you're standing at the site frontage, looking up the Glen Road. That's the adjacent house to the east, and the site then is on the left-hand side, the Rushy Field. You sort of imagine you spun around 180 degrees looking back down the road, and that's down towards the bungalow then on the left-hand side of the site. Views then just standing on the road looking in, so you can see the left-hand side there's the existing house. You have the field gate coming in, the field then, and then the right-hand image looks more to the right-hand side up towards the house to the east. And there you can see then, so that's the rest of the field looking up towards the house to the east. So I'll just a few more images. These show the width and the expanse of the field. So that's number 21 further down the road. Our application site then is on the right-hand side. You can see the trees along the background there. And then further down towards number 21. So in terms of the policy conflicts, members, I'll not go through them all, but you can see there's a number of issues that the application is considered to be contrary to, and it's not considered to be a rounding off opportunity. One of the key ones, though, members, for planning officers is this issue about the alternative development opportunities, so criteria H. In addition to all the other issues, criteria H is an issue, and the application is considered to be in conflict with this. So the red line goes around the entire field. You can see it's been recently cut there in the flyover image. So the proposed site is where the yellow star is. The red line now goes right around the whole field. There would be room then on the left-hand side of this site for another dwelling where the red star is. And so therefore the development would result in further development opportunities if approved. In terms of the site itself, you can see the adjacent 2 buildings are about 60 to 70 metres. So 63 on the left, 67 on the right. The site itself along the middle is about 130 metres. So the plot widths of the 2 houses either side would give you about 60 or 70 metres. Again, that would easily allow for 2 plot widths of comparable size in this field. You then have the application site as the yellow star, which leaves room for another development opportunity on the left. So although the red line goes around the whole field, there's clearly an opportunity for another dwelling to be approved on the left-hand side of this site. It is in an area, though, that's affected or partly affected by surface water flooding. And you can see there in the image on the right shows this purple area, which is the surface water flooding. However, the policy and the plan strategy does not stop people developing in areas that are affected by surface water flooding. It does for fluvial, so rivers and things, but it doesn't for surface water flooding. And we as a committee and as a council have approved houses on sites like this, despite objections from neighbours. So it just requires that adequate drainage measures are put in place, and there's plenty of room to do that within the site without impacting on any neighbours. So, members, a number of issues there. The application is contrary to HU 13 and the various criteria there. It will also not be an infill, but it's really the rounding off opportunity is what the applicant is proceeding on. But it's not considered to be a rounding off opportunity, an infill opportunity. It'll also alter the rural character by reason of build-up. So you lost the gap between the two houses and created then a line of buildings along the edge of the road, which will create a ribbon of development. So for the reasons listed within the report, and in line with the wording of the regulations, when reading the DDP and the plan strategy together, the proposal does not accord with the plan. And there are no other material considerations to indicate that it should be approved contrary to the LDP.
Thanks for that, Darren. We have speaking rights. We have David, and we already confirmed David's online there. So David, as you know, you have 10 minutes to make your submission to the committee. So whenever you're ready, David.
Perfect. I'll knock the video off, maybe in case it eats up some of the power that I have. Thank you, Chair and Committee, for allowing me to speak on behalf of Beatrice Keys. You will recall this application, as Darren mentioned, was in front of the committee last year. And if your memory serves you correct, we had a small area of blue coming down to the purpose of the road, which the committee members, I think, felt that there was opportunity for a second site in here. This is a one site application. We're not going for two. Darren did mention obviously the flood, surface water flooding. I have concerns on that, and that's why I've pushed the house to one side. If we go back just first of all to my overview map, I can put one in for that this morning. If you can pop it up, please, Darren. But it's the map that you had up at the very start with I had a big heavy black line around it. You will see, I know that one there, yeah. Well, I'll be a wee bit closer, but it doesn't matter. You can see the site that I currently have is all included in red. That was based on the comments I took away from the last committee meeting, that there was no other opportunities for a second site in this. You can see the width of the frontage of the green site and the width of the frontage of the blue site. We're disregarding the red because it's, as you say, it's an under. But Darren showed the map there with the different frontages on it. That's not strictly correct. 21 in green is a lot wider. We always base our frontage on the development limits of the site, and in my case, my green site is where the entrance is, which is the curtilage, within the curtilage of the site. On the green is quite lengthy. And as I say, the client has always confirmed there's only going to be one dwelling here. There's no opportunities for a second. So to go down through the development of new dwelling as a rounding off will be permitted where all the following criteria are met. The proposed dwelling will result in a rounding off of a gap within an existing group of buildings which are sited outside a farm. You can see from the overview, which we're assessing as a rounding off. I'm asking the committee to consider that the black dashed line is the rounding off of that junction. It's a junction of two roads. It doesn't have to be a crossroads. It's a junction of roads. It states in the policy. So we've met the criteria of creating a focal point. Is what is the extent of the focal point? Now you can see the number of houses shaded grey. You can see the two buildings to the south of the blue site, and it's buildings that we talk about. It's not dwellings. It's buildings within a rounding off opportunity, and we have 1, 2, 3, 4, 5, 6, 7, 8 buildings at a junction, at a focal point. So to me, I feel we've met criteria. You'll also in Niles Front, we talked about that. As you drive south on the Drumscrow Road, no matter what way you run here, coming from the east across to the west, you're hit with the Drumscrow Road number 73 and the houses further up the Drumscrow Road on your right hand side. You're also driving through houses. No matter where you are, the house that we're proposing will read in between the blue and the green site. It won't be adding to ribbon because it fits nicely and snugly within the green and the blue site, within the red line. So I believe the rounding off criteria has been met, and we have met with criteria A of SPO5. B, the existing group of buildings appears a focal point at a junction of roads or a landscape when viewed from a public vantage point. Your public vantage point is Drumscarrow Road and the Glen Road. The Glen Road in particular would be the priority road. It drives from east to west or west to east. Drumscarrow Road, you turn off that to go up to the quarry. We have the junction of Drumscarrow Road and Glen Road as a criteria of the meeting stroke junction of roads. As photo 2 indicates, the dwelling are all visually linked. Photo 4 was taken on the Glen Road without the gym. You read a row of dwellings all on the way to number 21. So if you drive from 70 to 21, our dwelling between the two will all read together. There's no addition. Ribboning, as I understand, is the addition of another dwelling beyond the dwellings. We have 2 bookends here of a site that'll quite easily take the gap. So I think we've met criteria B. The proposed dwelling visually linked with an existing group of buildings number 4, 3 of which must be dwellings, each with their own defined curtilage. It's Drow Road, but as you drive up and down the Glen Road from west to east, roughly, you will read all 3 together. No matter where you come, as you come down the Drumscarrow Road, come down the Glen Road from the west to the east.
David. Sorry to interrupt you, David. You broke up quite badly there about a minute or so back.
Oh, chippers, right, okay. I'll start the ramble again then. Can you hear me okay?
Yes, it's not too bad there. Just I'll let you know again if you break up. All right, David?
Perfect, thank you. So suppose when you're driving west to east or east to west on the Glen Road.
No, sorry, David. Sorry, David, we're not. You're not hearing me, David.
The main sites, which are 2 quite strong bungalows with road frontage.
Sorry,
also
David.
The third building, which is
Sorry, David.
Road. Oh, wait again. Gosh.
David,
Yes.
sorry, you're
good. Can you hear me? Yes.
No.
Yep.
Hold fire, David. We're not getting you. I'm aware that you have a written submission. If you don't mind, we transfer to the written submission. Darren would give the rest of the information.
Perfect.
Right?
Finish off.
Give us a minute or so, David. But it's just
Perfect,
broke up
thank you.
entirely there.
Remember, so just in the interest of fairness, I'll just really start at the top. It does repeat a lot of what he had said, but I'll just go through it. The statement is on the portal and is there to view, but I'll just summarise really. So the application was previously before the committee, and as the agent said, if memory serves right, the only concern was that the site was split into 2, one red and one blue. It was always the intention of the applicant to have 1 dwelling, and it remains the case now. The agent considers the site as a rounding off opportunity. There are 6 dwellings, 3 farmyards within 150 metres. Number 21 and 17 either side, and you can see number 76 Drumscarrow Road and number 21 Glen Road. This is rounding off. The junction of the Drumscarrow and the Glen Road is nearby, and the dwellings are visually linked with this junction at a focal point. There's 3 dwellings, 2 garages, the farmyards and the buildings in the area, so it complies with the criteria B and C. The site then is bounded by development at both sides. A strong planted boundary to the east along the site boundary meets criteria D and integrates. The site or the dwelling will not result in the coalescence of 2 visually distinct groups of buildings, 1 visual entity meeting criteria E. The site is an ideal site for a dwelling. With the dwellings on both sides, it will be a traditional dwelling and therefore not alter the existing character, fills in a small gap and will not visually intrude into the countryside. It can't add to a ribbon as it's within 2 dwellings and its class really is rounding off. The entire site is outlined in red. It extends right across the complete frontage, leaving no opportunity to access the retained lands. Planning would be difficult to get as it sits behind another access. The agent considers the application to cluster at a junction of roads does not add to a ribbon and meets all the policy tests.
Thanks for that, Darren. At this juncture, we'd normally have questions for the agent. I'm not sure how that would work. Has anyone any indication? Any questions?
Can you still hear me okay? Can you still hear me?
Yeah. Just bear with
Well
me.
done, Darren.
See if there's any questions for you.
I was going to thank Darren. That wasn't badly wrote. Yep.
You're welcome, David. Okay, there's nobody indicating with questions, David, so we'll just proceed.
Thank you.
Okay, happy. Thank you, David. It's over to yourself now, Darren, for comments on the submission there.
Members, a lot of these issues really are judgments for members to make for themselves. Well, I just clarify really in terms of the policy, the rounding off policy we have, it's not that there needs to be a junction, a road junction or a T-junction or crossroads, anything. What the policy is saying is that the existing group of buildings, so the existing group of buildings appears as a focal point at a junction of roads. So it's the buildings themselves appear as a focal point at the junction of the roads. So that's different to the way it was previously. Previously in PBS 21, you had to have the focal point. Now what we're saying is that the buildings themselves appear as a focal point at a junction of roads. So there's a slight difference there. In relation to the other issues, members, they are judgments for you to make a decision on today. Planning officers put forward the reasons in the report and in the presentation, and the agent's put forward his case. In relation to the alternative development opportunities, members, I know the agent says that they only ever apply for one. About £1 for every time I'd heard that, regrettably. But in this case, it's the physical size of the site that planning officers are looking at. The size is big enough to easily accommodate a second house or a similar size plot in relation to the nearby plots. Access can be achieved in off the public road. Roads have no issues to a paired access adjacent to any existing site. So there's no physical constraints that would preclude any development of a second dwelling in here. If this approval is granted, a second one will follow if it is applied for.
Thank you, Darren. Thank you, Darren. Okay, open to members now. Discussion. Councillor Campbell, go ahead, Glenn.
So, Harley, well, I suppose it's on that issue around the potential of a second site here. I think the agent, from what I heard, and in the statement there, said that that potential was unlikely given the fact that there's a sweeping entrance, and effectively that potential second site would be behind that entrance. It would be, they felt it was unlikely. But I suppose we're looking at a rounding off application here, not an infill. Darren has said there that the infill couldn't have worked given that there's an illegal or a building, a structure that doesn't have permission, that there's only two houses rather than two dwellings. If there had been three dwellings, we would have been in a different situation here where two sites would have been acceptable. And what I'm getting at is, what is the agent feels it's unlikely, Darren feels it's not unlikely that there will be a second application. What would be the harm, if you like, given that the other part of this policy would have, where it's relevant, it's not relevant here, but the other part of this policy would have put two houses there, two sites, if the condition was met around the three dwellings, you know? So I'm just wondering about the harm in that potential, given that it's bounded on each side by other developments. I'm just saying that we're not looking at the extension of a ribbon here. We do appear to be filling a gap. That, just to put that there.
Yeah, I think Philip mentioned the last application about a rational decision. So whenever we do issue and make a decision on this application, it needs to be defensible and sound. So you have your planning policy, you have two different policies which apply to the countryside. The infill one allows for two, the rounding off is for one. And the rounding off is for one because the idea behind the policy, when you look at the background papers, is you would have a lot of houses in an area and you could stick another house in there and you wouldn't even notice because the area is already built up. So there's already lots of buildings there. You have a wee small gap, put one house in. That same principle or context wouldn't apply necessarily for the rounding off for two because the gap would be bigger. So there'd be more space between the houses and bigger gaps. And the way they're scattered about in rounding off opportunities, they're scattered about the place, so there's less chance that you could put those houses in and not change the character. With ribbon development, it's very obvious what a ribbon development is. We get a lot of them. There's a lot of them around the countryside, unfortunately, where you have a line of houses along the edge of the road, and along that line, you can see them driving along the road. They all appear as a line, and you can have a gap sometimes for two, and You can put 2 houses in there, it'll not change the character at all because there's so many houses already there along that line. So there is a difference when you're looking at the two of them. In terms of today, going forward, members, if you're saying that, you know, you'd be content to allow 2 houses potentially under the ribbon, under the rounding off opportunity, that would be contrary to your plan strategy and contrary to the policy. So you'd have to make that decision fully aware that you're saying it doesn't meet the policy, but I want to approve it. And here's the reasons why. The difficulty with that, members, is you're opening the door here for precedents for everybody else to come along. There would be no difference between this site and potentially many, many other ones around the countryside. So there would have to be something unique here that you would be saying on this specific site, you're agreeable to allow this to go forward contrary to the plan strategy, and not opening the door for lots of other sites around the area. In terms of the other application for another site on that, members, I'm not saying whether it's likely or not or whether they're going to ever apply for it. All I can show you is the evidence before you. When you look at the plot sizes and the size of this site, it's very difficult for for a planning officer to sit and say you wouldn't approve another one in there.
Thank you, Chair.
You do. Councillor Irwin? Go ahead, Robert.
Thanks very much, Tommy. I've heard what Darren says. I also heard what David said with regard to creating a ribbon of development and his interpretation of a ribbon. That would be slightly different to my interpretation of a ribbon of development. Because it's gone under HOU 13 and trying to create a focal point, my interpretation of what I'm looking at, both from the visual presentation through the photographs and the flat plan layout of what's there, it's actually a pattern of development that we got a lot in our countryside, where you have a dwelling, a medium-sized space, a dwelling, and then you come up to a junction, and then you turn down another road, space and a dwelling. So I don't think in my mind that he has created that the cluster of dwellings in his outline actually create a focal point in the countryside. They actually just highlight a pattern of development that we have within our council area. And if you look at the farm buildings to the south of Glen Road, whilst they're outlined in black and everything like that, they wouldn't read with even the dwellings on the junction. Take away the gym because it's not there. It's going to be away, and pattern that up. So what you have basically coming down the Culper Road is dwelling, farm dwellings, a fairly large space, another dwelling, a junction, and then turning down the Glen Road, you will have a large space, a dwelling, another very large space and a dwelling. And to shoehorn something into the site, you're right, with all the will in the world, you could have 2 dwellings in there, irrespective of whether the agent said they're going to have 1. So my interpretation is that the planning officer's recommendation and discussion around it is correct. And with that, I'm going to go with a proposal that we go with the recommendation and refuse this application. Thank you.
You, Councillor Irvine? Any further comments, members? Need to move this along, members? Am I allowed? Is there any further questions from members? Further clarification required? Go ahead, Paul. Councillor O'Reilly, go ahead, Thomas.
Chair, I'm prepared to second the recommendation.
Thank you, Tom. Okay, members, we have a proposed by Councillor Irvine, second by Councillor O'Reilly, that we go along with the officer's recommendation to refuse the planning permission. Are we all agreed?
Great.
That seems unanimous. Thank you, members. Just to sum up there, Darren, please.
Okay, members, so paper B, application number 2, LA 10 2025-0090. The recommendation was to refuse planning permission for the reasons listed within the report. Members have refused planning permission for those reasons.
Thank you, Darren. So we're moving on now to application number 3, proposed site for infill dwelling domestic garage. Okay, mechanic, go ahead, Darren, please.
Okay, members, so application number 3 then, LA 10 2024-1244. An outline application for a site for an infill dwelling and domestic garage for K. McCanny. The location then is approximately 70 metres east of number 89 Glen Road in Drumquin. The recommendation is to refuse planning permission for the reasons listed within the report, subject to the 3 reasons. We'll just take you through some of the details, members. We have the site location plan then is on the screen. You can see the site identified in red with additional lands in blue within the applicant's control on the right-hand side. There are 3 other buildings in, other dwellings in nearby, and I'll go through those in a second. So you can see their position in relation to our site. So the existing site plan then provided by the agent shows number 89, number 89A and number 85. And there's a laneway then up to number 87. Our site then is a rectangular field left of 85. And the potential here, members, is for 2 infill dwellings. So the application is just for 1. It's the left-hand side. And the plot sizes would be comparable to the adjacent buildings nearby. You can see the 2 of them there on the screen. So an aerial view then, looking down at the site, you can see the pink dot really is the field that the application is in. And you have the buildings in on the left-hand side and the right-hand side. And other buildings in nearby, including across the road. So the street view image then, these are provided by the agent. So you can see on the left-hand side the number 89, and then the laneway then running up. You can see the wooden cabin there, the brown wooden cabin. It's quite difficult to spot there, set back off the road on top of the lane. That's number 89A. The application site then is the right-hand side of the brown wooden gate, or the brown wooden fence and field gate on the right. And then number 85 is further on up the road. So if you're just standing at the laneway again, looking at the field, application field, you can see the other 2 buildings to the left. You've then the 2 lanes and then the green field running up to the property then further to the right-hand side. So again, remember, you look from the report some of the issues. One of those is that the area has retained its rural character and there's no real build-up of development due to the separation distance between the existing buildings and their location and setback from the public road. So you can see number 89 then is about 163 metres of a separation distance from 89 to 85. 89A then, the brown wooden cabin then, which is set back from the road, is about 122 metres or so from building to building. So a significant distance between the 2 properties on the left and the one on the right. So it's not just a case of measuring the site frontage where the application is, it's really looking at the distance between the buildings and identifying whether there's a build-up of development and the character has already really been lost, and therefore there's a substantial and continuously built-up frontage. So again, then just some more Google Street View images. So if you're driving along the road, the Glen Road, the application site's in front of you. You can see then number 85 on the right, another property on the left. The site then is to the left of 85, and then you can see the other house, number 89, further along the road. So just driving along, members, you can see the existing property on the right, and the site then is just on the field on the right-hand side of the road up towards 89. Again, then another image, so the house on the right-hand side, you can see the field then, the road frontage field, and you can see number 89, the white bungalow. 89A then is the brown cabin. I'd say it's quite difficult to spot, but it's there, just you can see the pitch of it there above the yellow gorse. And as you come a bit closer then, you can see 89 and 89A. And then really just along the frontage, looking up the laneways towards those 2 properties. So just go back the other direction then. So you're at 89 here on the left and the laneway at 89A. You can see the field then in front of you and 85 then further along the road. So again, just traveling back along the road. Remember, you can see then the gap between the 2. So the issues in relation to the application then, just remember this is in the Sperrins, AONB, so it's an area really of of outstanding natural beauty. The area has retained its rural character. Nearby buildings are dispersed and there's no built-up frontage. The site's an important visual break. Its loss will impact on the rural character and result in suburban build-up, create a ribbon of development, and there's no really pre-existing line of continuous built-up development. So it's an important visual break, and the loss of that visual break would adversely impact upon the character and appearance of the area. So the application is contrary to the plan strategy for those 4 reasons. It's not a rounding off, it's not an infill, alter rural character, important visual break, and create a ribbon of development.
That you, Darren?
That's the agent. He's going to come up, use his clicker.
Yeah.
Going forward.
We have speaking rights on this application, Eugene Corrigan and Mr. Kieran McCanny as well. So if you come to the seats there, please.
It's all set up there.
You're welcome again, Eugene, and Mr. McCanny. And Eugene, I believe you're going to use a bit of technology that you're going to be the first to do this. So we hope it all works out better than the online with Mr. McKinley. But so you're aware you have 10 minutes to present to the committee, Eugene, and you can share the time out between yourselves. Okay, I will give you do you wish an indication at 5 minutes maybe to allow Mr. McCanny? Or yeah, it'll just be yourself, Eugene, you lead on it. Okay, happy enough? Go with me, Eugene. There you go, Eugene, at your pleasure there.
Thank you, Chair. Thank you, Darren. Hello, members. I am Eugene Corrigan, the agent for this application, and I appreciate this opportunity to speak to you today. Beside me is Kieran McCanny, the applicant, and he is here to answer any questions you might have. First, I have a bit of background information. Please look at slide 1, a map of Kieran's farm. Kieran is a farmer, and this proposal is for his son to build a house on the farm. It is not an application for a house on the farm per se, but it is the best opportunity on the farm in terms of sustainable development. He could get a replacement for an old disused dwelling on the farm, but it is way up a long lane about 300 metres from the road. It has no existing electrical supply, nor does it have any mains water supply. So the cost of providing services to it effectively rule out the feasibility of building a house there. Whereas our application site is along the side of the road and all the services are available adjacent to the site. Kieran has never sold off any sites or development opportunities from the farm holding. The farm is approximately 40 acres in size, and the slide indicates in red outline the farmland owned by Kieran. Strategic Policy SP01 permits development proposals which further sustainable development and promote measures to mitigate and adapt to climate change. This application is for a house along the roadside where all services are available. If this application is refused, then he will be forced to apply for the alternative, which requires substantial additional costs and infrastructure. The 300-metre lane required and the installation of services required will cause additional demonstrable harm to the environment, so we have mitigated against this by applying for this infill site. Paragraph 2.15 of the plan strategy states, clustering, consolidating and grouping new development with existing established buildings in the countryside facilitates new development which can benefit from the utilisation of existing services such as access and drainage. This can simultaneously mitigate potential adverse impacts upon rural amenity and scenic landscapes arising from cumulative effect of one-off sporadic development. As the application site is located in the rural area, it falls to be assessed under planning policies DE01, DE02, 03, 04 and 05. The planning officer's report states that our application complies with DE01, DE02 and DE04. Therefore, they are satisfied that if approved, the development will integrate into the countryside and will cluster, consolidate and group with an existing established group of buildings. This application is being refused under policies DE03 and DE05, but the main reason, in simple terms, is that they do not agree that there is an existing substantial and continuously built up frontage. Slide 2 is the concept plan we provided with the application. As you can see, there are existing dwellings on both sides of the proposed site and on the opposite side of the road too. The concept plan shows how well this development will sit in amongst this existing cluster of dwellings. Under policy DEO3, the plan strategy allows for a number of different types of housing in the countryside. Our application is to be assessed under policy HOU 13 of DEO3. This relates to rounding off and infilling. As you know, infilling will be permitted by paragraph 2 of HOU 13 within a line of buildings where the proposed site is a small gap suitable to accommodate only 2 dwellings within an otherwise substantial and continuously built up frontage. This policy states that a substantial and continuously built up frontage is a line of at least 3 buildings, each with their own defined curtilage. In slide 3, you can see there is indeed a line of 3 buildings, each with their own curtilage. Is this not substantial and continuously built up frontage? The planning officer thinks it is not and says that numbers 89, 89A and 85 do not read together. We would contest that they do. As you can see in the photograph, they quite simply do read together in a visual line. The policy does not say it has to be a straight line and that one of the buildings cannot be set back slightly from the others. Planning is a visual test, and in this case, it is clear that there is a visual line of development. Numbers 89, 89A and 85 are an existing ribbon of development. If the planners are saying it is not a ribbon, then I would like to know how it is not. Our proposal will not form a ribbon, it is existing, nor will it extend the ribbon. Our proposal will infill a gap in the ribbon, and this will consolidate and round off as allowed under policy HOU 13. This gap between the existing dwellings is large enough to accommodate 2 dwellings, but the applicant is content with only 1, which he is entitled to do at this stage. The planning report states that a dwelling in this location will result in a build-up of development, but policy HOU 13 allows for this in the form of infilling and rounding off. As discussed, the reasons for refusal are all based on the location and nature of number 89A Glen Road. They say that because it is set back slightly from numbers 85 and 89, then it is not considered part of the existing ribbon. This is not true. Ribbons of development are a visual existence. The planning report refers to a High Court ruling where planning permission for an infill site in County Down has been quashed recently because it was deemed that planning policy had been breached. I have looked at this application on the planning portal, and the reasons for refusal are different to our application, so it is not a relevant argument at all. County Down application is different because the line of development there had 2 gaps in it. Therefore, it was not a continuous line of development. It clearly breached the policy, but it was different to ours, so I don't believe this Duff judgment line can be rolled out for every infill application. The Duff judgment case rightly states whether or not a substantial and continuously built up frontage exists is a question of planning judgment. However, that judgment must be informed by the physical facts that exist in the relevant area of land. And it says, planning judgment cannot erase observable facts. Well, when I first visited this proposed site, the observable fact was that there are 3 existing dwellings in a visible line when viewed from the road. All the way along the road for a distance of approximately 250 metres, these 3 dwellings are visible and read together. Again, the policy states that infilling will be permitted within a line of buildings where the proposed site is a small gap suitable to accommodate only 2 dwellings within an otherwise substantial and continuously built up frontage. For the purposes of this policy, a substantial and continuously built up frontage is a line of at least 3 buildings, each with their own defined curtilage. In my view, this is a visually assessed policy, and you can see from our slides that all 3 dwellings are visually linked in a line and they all have their own curtilage, therefore complying with the policy. Policy does not say that if one is set back slightly, then it must be discounted. And it doesn't say how big the buildings must be, or how small, or how they must be orientated, or what finishes they must have. They must only be buildings in a continuous line with their own curtilage, with a small gap site to infill. Please look at the 4th slide, which is an extract taken from the planning publication Building on Tradition. Taken from page 71, there is an image that demonstrates the type of sites that are likely to comply and sites that are not likely to comply with the infilling policy. The purple shaded examples would be refused, and the blue shaded sites are likely to be approved. You can see that we have identified 2 sites at the bottom, which the publication states are likely to be approved. In both these instances, there are gaps within lines of continuous development. But also, in both cases, these lines of development are not necessarily in a straight line. Very much like our application, some of the buildings are set back further than others. This is the publication we are encouraged by the Planning Office to use when preparing our planning applications. So I contend that our application falls within the examples indicated that would be likely to be approved. In the Planning Officer's report, they were also recommending refusal on the basis that number 89A is not a permanent building and its construction materials are of a temporary nature. At the early stages of this application, when I was talking to the Planning Officer, this was very much part of the reason for refusal. But I pointed out that this is
Just
not
1 minute
relevant.
left.
Yep, I'm nearly finished. But I pointed out this is not a relevant reason for refusal. The building in question, number 89A, has been in existence for over 15 years. It is a permanent dwelling house. It might look like a log cabin, as I was told, but that should not matter. Policy states that it must be a line of 3 buildings, and this clearly is. The planning report refers to the Duff judgment several times, but this is a red herring. Duff judgment application had a second gap in the frontage, and that is why it was breaching the policy. Our application is a continuous line of curtilages with only 1 gap, which is the proposal site. I think we can all agree that our application is different to the County Down case, and that in this case, we do have a substantial and continuously built up frontage. The planning report agrees that if you decide that we do, in fact, have a substantial and continuously built up frontage, then our gap site is an acceptable size and does comply with policy HOU 13. So you can propose to approve this application. We look forward to your decision, and we can answer any questions you might have. Many thanks.
Thank you, Eugene, and exactly on the 10 minutes to Eugene. Very well done. Okay, opportunity for questions, members. There, Councillor Campbell. Go ahead, Glenn.
Margaret Carty, just a question for Eugene. Just to confirm, I can just about make out, I think, this is the start and beginning of the ribbon from 85 to 89.
Yeah.
There's no scattering of houses beyond that.
There are other houses on the road. There's one across the road, so it is a cluster
Right, but
of sorts.
On that side of the road, this is the ribbon, there's no beyond. Yeah.
Yeah,
I just wanted to clarify that. Thank you.
that's fine, but that does constitute a ribbon of development.
Yeah, no, yeah, I understand. Yeah.
Okay, Councillor Irvine. Robert?
Probably 2 questions. One, did you have any discussions prior to submission of the application with officers, Eugene?
No.
The reason I asked that, you've obviously discounted applying for a dwelling on the farm because you think you weren't going to get it, but that's another comment I'll have later on. The second one is your interpretation of a substantially built up frontage.
Substantially built up frontage.
Yes.
is
You're saying
a line
that
of 3.
89A has a substantially built up frontage. What's your interpretation of it, looking at the visual?
No, 89, 89A and 85 is the substantial built up frontage. It's 3 buildings in a line along the road with possibly a gap in between. It only has to be 3 buildings with their own curtilage.
That's okay, thanks.
Okay, any further questions, members? Councillor McCann, go ahead.
Yeah, thank you, Chair. Now, maybe just get clarity from the agent in terms of the comments you made at the start about the application or the potential proposal up the lane. I don't think he said he didn't think he would get it. It just probably wasn't commercially viable and he didn't go down that route. But maybe just get that clarified, or.
You can ask here, and there is an existing dwelling up there. It's disused. It hasn't been lived in. It's the old homestead, I suppose. But it could get planning permission for replacement if it was applied for. But it's 300 metres up the lane. It's going to need a new lane. It's going to need electrical supply up there. There's no water. They're using an old pump well up there. So it's just the logistics and the cost, and so we decided that, look, there's an opportunity here for an infill site. We may as well go for that, and that's what the Sun wants rather than building up a long lane.
Just to say, Chair, that's absolutely reasonable, and I do think this committee in this particular area, not that far away from where Mr. McCanny lives, we did actually approve a farm dwelling a number of metres away, quite substantial distance away from from where the farm buildings were for that main purpose. That there's up a long lane and you know, there was challenges there. So what you're doing is prudent, in my opinion, Eugene.
So that's Stephen and Eugene. Do you wish to add anything here? Are you happy enough with? Sorry, I'll just let you.
From my point of view, the farm's a fifth generation, and son's 21, and he's took an interest a bit in farming, whether it'll happen or not. But I want to try and give him a step up, try and provide somewhere where he could live at the farm instead of maybe going somewhere else, going to town, different way, and that leaves then the farm going derelict. And he's only have the one son, so it's kind of family thing too, as such. Keep the thing going.
Thanks for that, Kieran. Any further questions? Nobody online indicating there? No. Okay, Eugene and Kieran, you can return to the seating area there, and we'll
Thanks, Chair.
go to Darren for comments then, please.
Okay, members, just a few comments really. I'm happy to take questions as well. Just in relation to the replacement dwelling that was a discussion on. Obviously, members didn't discuss that or come to any conclusion or decision on any application that maybe for that would be considered on its own merits if one is applied. Even then, it's not relevant to this application. You can have the replacement and you can have an application for an infill. You know, one doesn't rule out the other. So I would just set the replacement dwelling to the side and give no weight to it. If they want to apply for it at a later stage, it'll be considered on its merits. In relation to the Duff judgment, we can seek legal advice from Philip if you want. The Duff judgment does relate to another council area. It does relate to a different planning policy. But when you read the background and what they're discussing in that Duff judgment, it is all relevant to infills and rounding off and etc. So the commentary of the appeal judges would be very, very similar to any decision that we would have if we are judicially reviewed and we go to court. The same issues will apply, the same arguments will apply. So you can't ignore them. They have to be taken into account. What you do with those, though, members, is for yourselves to decide and determine. But it's certainly not a red herring, I think was the comment. It is material. It's something we have to take into account, and it's included in your reports for that very reason. In terms then of the actual rest of the issues, the reason for refusal, members, those are decisions for you to make today.
Thank you, Darren. Councillor McLaughlin, go ahead, John.
Okay, Darren, I mean, this is probably one of the ones that we debate the most is the infills. And for me, looking at this, 85 and 89 are buildings. There's a space there where there's two sites and that's not contended. 89A seems to be where the contention is, and even if it's a log cabin, it's a building, it's there. In the last application, we were looking at a similar lane, and we were putting a house behind that and saying we could put a second house in there, and that wasn't the reasons why, but it's a similar sort of entrance, offset, and runs along the side of the road and then up to the house, and then we were going to put a house in the space behind it. So we have a log cabin there, and there's a lane. You can see it from the road. It's clearly in its own curtilage. So that would give us, is that, am I reading this right? That's the crux of this is whether we accept that the 89A is a substantial building with a frontage, and then we have 3 buildings and we have space for 2, and that's an infill.
So it's, if only it was, it's not a simple question or test of counting houses and counting numbers. And you know, you're not looking at an aerial image and going 1, 2, 3, there's a gap for 2. And we move on to the green farm. The Duff judgment, that's why it's included in there. It is really of assistance to the judge has set out what you have to do when you're trying to consider whether there's a substantial continuously built up frontage. What you have to do is you have to look at the facts on the ground and look at the location of those buildings and see whether they all read together as a substantial and continuously built up frontage. So if you're driving along the road, do you see it all built up with buildings, essentially? So whether or not a substantial and continuously built up frontage exists is a question of planning judgment. However, that judgment must be informed by the physical facts that exist in the relevant area of land. Planning judgment cannot erase observable facts. So to say, it's more to do with the views you get from the public road you're driving along. Do you see a substantial continuously built up frontage of 3 houses, or are they all scattered and spaced apart with a large gap between them? That's the view of officers at the moment, that the area has a rural character to it, a rural feel. There's a significant difference between number 85, you can see on the screen there, and 89 and 89A. So there's not a substantial continuously built up frontage. In relation to 89A members, the fact that it's a log cabin might have been in the initial report. It's not in your report today. It's not an issue. The fact it's a cabin, it's not an issue.
Okay. Councillor Campbell, go ahead, Glenn.
Mr. Carey, well, I would agree that certainly I welcome that clarification that there is no issue with 89A in terms of its constitution as a building, a dwelling. So, okay. So I'm just wanting to return to the second last slide that the agent presented. It shows 89, 89A and 85. Yeah, that's it, correct? And I suppose that's for me the key. It's very important, there's similar slides shown previously, to be fair. But that for me does confirm visually that there's three buildings with a gap. And that constitutes a substantially and continuous built-up frontage. And I suppose when we deal with ribbon developments, one of our concerns are, well, the main concern for me as a member of this committee is whether it meets policy. And it does, in my opinion. The only additional development that this creates is the fact that there could be 2 dwellings accommodated on this site, which the applicant would have been entitled to apply for. And really, developing one of these sites, I believe, opens certainly the opportunity for another. But that's not a concern for me. The fact is that it meets the policy in terms of filling a gap between a row of 3 houses, a substantially built up frontage, which happens to be a compact, and that's a good thing, really, in terms of rural character. It's a compact ribbon, but it's a ribbon nonetheless. And I don't believe the rural character will be negatively affected by the proposed development. And for those reasons, Chair, I would propose, contrary to the officer's recommendation, that we do approve this application as an infill under HOU 13. Thank you, Chair.
Thank you, Glenn. Councillor Feely, Anthony, go ahead.
Thanks, Chair, and thanks, and thank Eugene and Kieran for the presentation. It's very useful. I don't know whether I can know this, Darren. I just want to put it out there again and just keep my own head right. When we are making our decision, can we take into consideration, and I know the applicant mentioned there, if he was going to build on this side, he might have to build further in the lane, the cost of getting mains water, electricity and fixing the lane up there to get into a substantial amount of money. Can we take that into consideration when we make that? Is that not a planning issue? I just was wondering. My own. It may sound silly, but just wondering.
So the issue of alternatives, so what alternatives are available to the applicant, is not relevant to this application. Really, you're looking at this, does it meet HOU 13 or not? If it didn't, we would certainly be happy to meet with an applicant and try and see if there's an alternative with, somewhere on their lands that we could get. So the offer was always there. Same with the other 2 applications, but no, in this case here, you're looking at HOU 13, a narrow scope of it. Do you meet it or don't you, or not? And the other policies are irrelevant.
Thank you, Darren. And Councillor McCann, Stephen?
Thank you, Chair. I'm happy enough to second Councillor Campbell's proposal. I agree that this policy this proposal does fit in with HOU 13, and I agree with Councillor Campbell's reasons for overturning or proposing the overturn of the recommendation. But just on a second point, Chair, in relation to the County Down decision, I suppose this committee's never had an opportunity really to sit down, I don't think, and have a one-item agenda presentation on that particular decision and the details of that particular application. It may be beneficial maybe at some time, just so we can really get into the detail And like, you know, I know this thing about observable facts is mentioned, you know, very so often. We know what they are. Maybe just, you know, have a good detailed look at the application that it was assessed on, you know, and give us an opportunity maybe to really familiarise ourselves with it, because this, as you know, is the largest rural council area in the north. We do get a lot of these here. We stand to be impacted most greatly, I would say, by that decision. So it would do no harm to have that session, I think, at some point in the future.
Yeah, the finer detail would be helpful.
Really go into it, Chair, yeah.
Okay, Paul, have you comment there?
Yeah, thank you, Chair. And it's very timely, Councillor McCann, that you say that, because in the planning committee protocol, then we sort of undertake yearly training. So we have a workshop, we sort of scope dates for a workshop either late May or early June. So there is a couple of the Duff judgments that we want to go through, and then some other training as well, and maybe some further work on our improvement projects. So that'll be coming into the diary shortly.
Thank you,
Chair.
Thank you.
Okay. Councillor Irvine, Robert, go ahead.
Yeah, my interpretation is different, so I'll be voting against this recommendation, but just you can say what you want. But I think it's a point for noting and looking at the policy in future when we come to review the LDP, because the wording in the policy is their own defined curtilage. In my view of the setback 89A is, whilst you can see it, there's an issue of a shared curtilage rather than their own defined curtilage, because the only part of the curtilage that they have in their entirety is the width of the lane. Because they are set back, their curtilage is hidden behind 89, and the part that is seen is actually part or shared with 89A. So there's an issue of interpretation, I think, under the policy. So going forward, for a matter of clarity, I think we may need to look at that in a few years' time, just to actually provide clearer clarity on that issue. Thank you.
That may arise at the training. Maybe a good time to maybe have a conversation about that as well. Okay. So, members, I have a proposal from Councillor Campbell and seconded by Councillor McCann that we go contrary to the recommendation of the officers and that we approve this planning application. Councillor Irvine has already indicated his dissension from that. Are the rest of us agreed, members?
Agreed.
Thank you. And Councillor Bailey, agreed. Okay, that apart from Councillor Irvine, that there has been granted permission.
So application number 3, members, LA 10 2024 12440. The recommendation of officers was to refuse planning permission for the reasons listed within the report. Members have granted planning permission. In relation to conditions, members, could I ask the power to, for those to be attached to be delegated back to officers? There'd be standard conditions relating to houses in the country, likely to be a bungalow, which would appear to be the character of the surrounding area, so a ridge height of 5.5 or 6 metres. But we can certainly discuss with the applicant when we're coming to issue the decision, but there'd be standard conditions if that's acceptable.
Thank you, Darren. And Councillor McLaughlin, go ahead, John.
Yeah, I was actually going to come in and propose that. The officers, delegate powers back to the officers for
that, John and Robert.
Because I've gone against it, I won't say anything, but I was going to propose a comfort break after this. So it's.
I like your style, Robert. Have we a seconder for Councillor McLaughlin? Councillor Feely has seconded Councillor McLaughlin's recommendation for the conditions.
Yeah. Okay.
Okay.
Can I just, members, if you don't mind, just if I could just put in, if you don't mind, the Duff judgment is material, and it is referred to a lot in our applications that come before you. Just to remind you, there are a lot of applications that don't come before you that are approved and go through, and we've an approval rate that is very good. So there's no difficulty. So the Duff judgment is not closing down infill opportunities. They are still allowed, and we are still granting those. It is material, and it is something we have to take into account. It's only the ones that seem to get refusal that you get to see. All right.
Thanks for that clarification, Darren. We have a proposal for a comfort break. Have we a seconder for that? Councillor Campbell, thanks for that. We'll reconvene at 4:10. Okay, everyone ready to go? So moving on then to item 6 on the agenda, to note the schedule of planning decisions issued in March 25, and that's Sinead, please, paper C.
Thank you, Chair. So this is one of our standard monthly reports. So it's a list of planning applications that have been decided and issued in March just past. And it's for members' information. So during the month of March, 96 planning decisions were issued, and the detail of those then are set out at Appendix 1 to the report. So you'll see then we've summarised what those have been. So 78 related to planning applications. We had 8 CLUDs, 1 non-material change, and then 9 discharge of conditions. And then at table 1, then you'll notice then we have set out just what that looks like in the terms of March, and then looking back February and January. And then what the breakdown is in terms of refusals and approvals. And there's the table there then, also looking at that. So the recommendation then, members, is that the council notes the report of the planning decisions issued in March 25.
Okay, thank you, Sinead. Councillor McCann.
Thank you, Chair. Yeah, happy to propose and open to that. I suppose just to make the comment, and Darren touched on it earlier, you know, that we only see a small aspect of infills in that case coming through, but that report shows you the extent of the stuff that's going out every month. So listen, have to acknowledge the workload that our team are going through every day of the week, you know, so happy to propose that.
Thank you. And Councillor Irvine, go ahead, Robert.
Yeah, just a general point. I think we probably, well, in my estimation, we have our scheme of delegation pitched at the right level. Essentially, in other words, we know what has to come automatically to committee through whatever route, major or a personal interest. But I think the delegated items that go to our officers for decision then, and refusals, and that we see on a weekly list, and those that we bring in here, I think the debate that we have show that there are issues. Even though we adopted our local development plan, there are a few issues under some of the policy, particularly the ones that pertain to enterprise in the countryside and rural dwellings in the countryside. And as a note I've just referred to earlier in the committee, I think probably through our experience of the outworkings of that, we probably need as a committee to have a discussion and just see where any perceived, I wouldn't say gaps, but sort of fogginess in regard to what was the policy intent as opposed to the interpretation of the policy as it's written. And that's not to close a gap for applicants, but it's really to make sure we know what we want for our district, but also then that anybody applying actually has a better understanding of the policy and what is policy compliant and what isn't policy compliant. And I'm happy to see sort of, as we go down later, approval rates. Thank you. And if there wasn't a second, I'll second, yeah.
Report on the planning appeals decisions, March 25, paper D. Sinead again, please.
Thank you, Chair. So the purpose of the report is to provide members with an update on 2 appeal decisions by the Planning Appeals Commission during March 25. So just I suppose to look at just a couple of the key points from the 2 appeals. So the first one there, members you'll note, was an appeal against refusal of full planning permission. So it was for proposed infill site for 2 detached dwellings and garages, and it was at Cavan Road at Fintna. So you'll note then that the appeal was dismissed. And I suppose just important to note that the council argued the site does not constitute a small gap suitable for infill, as it was considered it didn't meet the criteria of substantial and continuously built up frontage, and also then would detract from the rural character by creating a suburban style of build-up. So the Commissioner considered the evidence and found that whilst there was a substantial continuously built up frontage, the appeal does not meet the criteria for a small gap site suitable for only 2 dwellings, as it could accommodate more than 2. And they've also noted that the site was deemed as an important visual break in the landscape, and the proposed development would result in a suburban style build-up, negatively impacting rural character and creating a ribbon of development, and the appeal was dismissed. And then the second appeal was in relation to an enforcement notice, and the breach was an unauthorised erection of a container, and that was at Roxtown Road, 6 Mile Cross in Omagh. And just, I suppose, a couple of key points from that one. Initially, the appeal was brought on multiple grounds. It's set out in the report. However, then later in the process, the applicant confirmed that they were only progressing with ground G, which was the one in relation to the time period that was specified in the notice in terms of compliance. So you'll notice then, members, that the Commissioner agreed with the appellant's request and extended the compliance period to 90 days, which they have said which would allow a reasonable period for the appellant to permanently remove the unauthorised container. But important to note that the enforcement notice was upheld with a very varied compliance period within it. So in terms of the recommendation, then, members, it's recommended that the Council notes the update on the planning appeal decisions in March 2025.
Thank you, Sinead. Would I have a proposer and seconder to note, please? Proposed, Councillor Irvine. Seconder. Councillor McCann. All agreed, members? Okay, item 8, to note the update report on the plan and enforcement for March 2025, paper E.
Thank you, Chair.
Sinead again, please.
So the purpose of this report then is to provide an update on the planning enforcement action during March 25. And you'll notice some of the key issues just set out within the report. So 20 enforcement cases were closed in March, with 21 new cases opened. So you'll note, members, that that leaves us with the number of live enforcement cases now sitting at 207. And you'll also note then that the detail of the 20 enforcement cases that are closed and the 21 cases that were opened are summarised at paragraph 2.3 and 2.4. I think it's probably important to focus in then on some of the graphs that we have within the paper. So you'll notice there, just in terms of the enforcement total live caseload, 24-25. So you can just see that those numbers and trend over the months back as far as October, and similar then in terms of the total live caseload. The other graph then, or table that we have included there, is the status of the current enforcement investigations, and that's at the 1st of April 25, and that's taken on board some of the comments and recommendations from previous committees. So you'll notice then that we have set out the detail of those. So the recommendation then is that the update report on planning enforcement is noted.
Thank you, Sinead. Proposed to note. Proposed, Councillor Mahan, seconded Councillor Campbell. Thank you, members. Moving on then. Oh, sorry, Councillor O'Reilly. Go ahead, Tom.
Thank you. I just want to make the comment, Chair, on the various graphs that we're getting now that gives us that little bit more detail and gives us a better understanding month on month how we're performing, and we can see more clearly where the trends are and what we're doing. So thank you just on getting that.
Thank you, Tom. Moving on now to item 9 on the agenda, to consider a report in relation to supplementary plan and guidance. Documents, paper F, and that's Paul. And Paul.
Thank you, Chair. So members, on the paper F then, and this relates to our supplementary plan and guidance documents. Members will be well aware of them at this stage. So the Council had agreed a suite of draft supplementary plan and guidance documents at the Planning Committee in February 2024. And at that meeting, we agreed that we had progressed with a public consultation, which was for an 8-week period on the 13th of April 2024. So the updated suite of draft SPGs and the comments that we had received following that consultation then was discussed at the LDP steering group meeting on the 7th of April. And I suppose the purpose of this report then is to bring that before the Planning Committee for decision. And the consultation report and the various appendices are all attached there. So if we go back to the draft plan strategy, members, at the consultation report, it was at that stage that the Council had committed to doing and providing supplementary planning guidance on various topics. So once adopted, the SPGs will offer advice and guidance to all stakeholders just on the relevant planning policies and their interpretation. I suppose it acts as a support for the developers and architects and the public just in their general understanding of how we apply the policies, and that ensures that it's applied consistently and effectively throughout the decisions. So it's just to be clear, members, that the SPGs, they do not introduce any new policy. There's no policy development here, no new policies, no amendments to policies. This is really only guidance and advice around existing policies. So once agreed and adopted, They won't have the same status as policies, but they will be a material consideration in the determination of planning applications. So we undertook the public consultation, members, and there was 9 submissions received from interested external stakeholders. And in broad terms, most of the respondents welcomed the draft SPGs and agreed with the substantive comments and content within them. There were a number of concerns raised, and the details of those are all set out within Appendix 1 within the consultation report and how officers have considered those. So a summary of the legal advice is also attached. We went through this in detail within the LDP steering group meeting. It's attached to Appendix 2, and I suppose if members want any sort of discussion around that confidential appendix, then we need to go into committee. Following the discussion at the LDP steering group, there was one query around commuted sums for affordable housing, and we have added one additional few lines in there just to provide clarity at paragraph 4.4. So the additional wording just basically says that the details of how a commuted sum will be secured, managed and used to deliver affordable housing will be considered on a case-by-case basis through the Section 76 agreement. And really, we don't want to sort of set out in too much detail how that might have happened within the guidance. It gives us flexibility that each case might be different. So as the SPGs don't introduce new policy, members, there's been no requirement then to undertake a rural needs impact assessment or a quality impact assessment. And you'll just see that all SPGs then have undergone sort of minor grammar revisions and formatting and imagery there. So they are ready now for publication. I suppose next steps in, members, if members are content with the final drafting of the SPGs, then we would suggest that they would take effect from the 12th of May 2025. That's the same date as our validation checklist and our enforcement strategy. So they've all taken effect at the same time. And we would have an agents workshop then just in advance of that. There's been a provisional date put on the diary for that workshop, and we'll take agents through all those 3 documents. So I suppose as part of the sort of move to a fully digital service, the SPGs will be made exclusively online, but there'll be hard copy formats available if someone needs that, and there'll be copies available in the Omagh Connect Centre. So notice of the final SPG documents and when they take effect, then we'll put that in the papers, members, as we normally do with our LDP policy documents, and we'll publish those on the Council's website. And we'll also actively promote them through the Council's social media platforms. So it's just to be very clear, members, here on what the recommendations are. So the recommendations, there's 3 elements to this. That we agree the contents of the report and the attached draft supplementary plan and guidance documents. That the homework on SPG, members, is progressed by way of an online self-service user guide rather than as a supplementary plan and guidance document, and the reasons for that set out within your confidential appendix, and that the Council proceeds then to the adoption and the publication of the supplementary plan and guidance documents. Thank you, Chair.
You, Paul. Councillor McCann, go ahead, Stephen.
Thank you, Chair. Thanks, Paul. And apologies, I wasn't at the last LDP. I know this got substantial discussion of it, so apologies, and this question may have been answered there. But Paul, you say that the SPGs are introducing no additional policies or amending policies, but you did also say that there will be a material consideration when assessing plan applications. Maybe just get a comment on why that would be the case. If it's our LDP is the policies, why would a guidance document or an advice document be a material consideration in a plan application?
So the various policies in, members, I suppose in terms of affordable housing, so that's set out within the planning policy HOU 3, I think it is, within the plan strategy. So obviously that the requirements within that policy then set out what is the test for any application in terms of affordable housing. So what the SPG does is provide guidance and advice around how we will interpret that policy. So what provision will be made, if there's the policy for affordable housing requires 10% of units. So, if on 10% there's not an even number, how it will be rounded up or rounded down. there'll be advice in terms of how it's phased. You know, if there's a phase scheme, how we'll approach affordable housing for a phase scheme. So that's how it all becomes material then. It's more detail around how the policy will actually be sort of interpreted and how we'll apply that then. So.
Chair, I wasn't at the last LDP meeting either. And one thing I remember there about the bond, that bond never introduced before. Is there a reason for that being introduced? Was it worries that, that's in fact worries big time too of this bond, because it's coming on to minerals as well. And we don't want that being passed on, the bond being passed on to the customer at the end of the day, because the stuff's bad enough at the minute, but if they start passing that on, you're talking about hundreds of thousands a year. And if a bond, will they have to pay that bond at the time of the application, or will it be a insurance one where you get written from them, it's a guarantee from them that they'll pay a bond if the work's not carried out to the proper standard?
Thank you for the question, Councillor Robinson. So the policy that requires a restoration bond, it's already been adopted. It's within the plan strategy. So we're not introducing a new requirement through the SPG. That's already there, and it's a requirement for planning applications. Where there's restoration, we will require a bond for all those applications. So that requirement's within the policy. As I say, this SPG sort of sets out how we'll interpret that policy, how we'll deliver it, what we would expect from the bonds. So in terms of the second question then, within the guidance, we've set out what are the different types of bonds that might be applicable. So cash a bond is one of the options that's there. Probably unlikely that someone will be depositing a certain amount of money within the council's account. I think they'd probably go for other types of bonds. We're not being explicit on what type of bond is required. We've just set out the examples. What we are being explicit is that there must be a sort of justification within the supporting statement for what type of bond has been chosen. And then the details around how that will be called down will be set out within the Section 76 agreement. I don't think there will be an intention, sort of be a last resort to call down the bond where there's been breaches in planning control. And certainly through the enforcement process, we'd be wanting to work with the operators, and really it would be a sort of a last resort before we would call down the bond, and appreciate there's different scenarios where operators may come in and take over a quarry. And I suppose we'll make provisions within the Section 76 planning agreement that if anyone comes in and takes over, then they would take over the bond as well. Thanks, Chair.
Thank you. Well,
Councillor Irvine. Go ahead, Robert.
Thanks, Tommy. But we had, those of us there were there had a good discussion in regard to what's coming forward in the paper. Just one thing I want to track back in your mind, really, affordable housing. The issue of substitution of a quantum of money or another site if availability wasn't within the actual site that was part of the application. So it's just to ensure that your discussions basically going down the line, particularly with the housing executive, bottom that out and we come forward with an agreed solution. Yeah, that's just a comment. Apart from that, I'm happy to propose all the recommendations because I've sort of been party to it. Thank you.
Thank you, Robert. Have we a seconder, members? Councillor McCloughery seconded. All agreed? Thank you. We're on then to item 10. And that's yourself again, Paul, for the planning applications validation checklist, paper G.
Yeah, thank you, Chair. So paper G then, members. So in terms of validation checklist, then members will be well aware of this now at this stage. We implemented a validation checklist in October 2022, and then subsequent revisions were agreed then in April 23 and January 24 as well. So in October 24, the Department for Infrastructure then wrote this and all the various councils just to advise that the validation checklist was going to be put on a statutory footing. And we agreed at that meeting, members, that we would undertake a public consultation on a draft validation checklist. And basically this report then, members, provides an update on that consultation. There's a consultation report attached to Appendix 2, and then there's also an updated validation checklist which takes account of the comments that we had received. So in terms of legislation, members, it's set out there within paragraph 2.1 and was made on the 1st of October, and we were notified of that, and it gives Council's powers from the 1st of April 2025 to introduce validation checklists for applications for planning permission. I think whilst there was no requirement in the legislation to undertake a public consultation, members, that sort of engagement with our agents and the public, there's value in that, so we agreed to undertake the consultation. A total of 5 responses were received, members, to the consultation. As I say, the details and the consideration, those are all set out within Appendix 2. Whilst the number of responses is low, members, I think this is considered to reflect the fact that the validation checklists are already in place. It's working well, it's well established. The agents welcome it. So I think overall there's a positive sign. It is, just to be clear then, members, that the updated validation checklist attached to Appendix 1, as before, it won't add an additional burden to applicants as part of the planning process. The extent of information sought is and will be proportionate to the scale of each application and the nature of the development proposed. It's acknowledged, and we've set that out within the validation checklist, that there may be site-specific instances when a particular survey or assessment may not be required, and each case will be assessed on its own merits. And we'll always encourage applicants and agents to engage with us where there's maybe any conflict or potential conflict there, and we'll be open to a discussion. Where an application then is submitted without all the information required in the validation checklist, the council and officers will, as we normally do, will discuss that informally and try to reach an agreement in the first instance. Where agreement then can't be reached under the new arrangements set out within the legislation, we'll be required to issue a formal notice, and that draft notice then set out in Appendix 4 for members' information. I would anticipate that it'll be very unlikely that we won't reach agreement with the agents, but that provision's there if there is disagreement. The applicant then has a period of 14 days from that issue of the notice then to appeal to the Planning and Appeals Commission, and then jurisdiction in the matter moves to the Planning and Appeals Commission for determination. In terms of the performance targets then, basically the performance will be taken from the date on which all information to make the application valid has been submitted. Legislation also requires the council then to review and republish the validation checklist at no more than 3 intervals. So again, Chair, if members are content with the updated validation checklist, then we had suggested it takes effect from the 12th of May 25, which is the same date as the new enforcement strategy on our SPGs, and that just give us a period of time to allow some discussion with our planning agents. So if members are content, then really the recommendation is that we would agree the updated validation checklist for planning application submissions, and that's attached then as an appendix. Thank you, Chair.
Thank you, Paul. Any comments, members? Okay, could I have a proposer and second to note? Thank you, Councillor Irvine. A seconder, please, Councillor Mahan. Thank you, David. Moving on to item 11 then. It's a consultation in relation to the Offshore Energy Action Plan, and that's over to you, Paul, paper H.
Yeah, thank you, Chair. So paper HN members, and this is a consultation then on the Offshore Renewable Energy Action Plan. So the Department for the Economy launched a consultation on that action plan, which basically sets out the findings of the strategic environmental assessment and the report to inform the appropriate assessment. Basically gives stakeholders an opportunity to input and the sort of offshore renewable energy policy documents. And the updated version of the action plan then is published alongside the other documents. So as a council then we had previously responded to, I suppose, the main consultation on offshore renewable energy options. That was back in March 24. This current consultation then opened on the 27th of February and it runs for a 12-week period. So all the documents are attached there, members. The draft response is attached to the Appendix 1, and it's just to note that that's been developed and drafted by both the planning and the climate change and sustainable development teams within the council. So the executive's energy strategy, Path to Net Zero, it specifically identified the need to diversify electricity generation with an initial focus on offshore wind and other marine renewables. And I suppose that's to meet the obligations then within the Climate Change Act of achieving at least 80% of electricity consumption from new renewable sources by 2030. So DFE lead the development of the action plan. And the action plan basically sets out what is an ambitious approach to the identification and delivery of the key actions then and collaboration with the delivery partner. So there is an action plan steering group which oversees all the work, sort of addressing the barriers, the deployment, and then seeking solutions to overcome those. And again, it seems to be a very joined up and coordinated approach. The consultation then acknowledges that by the end of our decade, there must be a significant increase in onshore renewable energy generation, but there is that need then to diversify to offshore. And really offshore gives a sort of an opportunity to boost the green economy, with new supply chains and skills, the service industry, and also just deliver new good jobs, members. The consultation document sets out broadly, as part of a 3-stage process, a number of refined resource zones, which are the least environmentally constrained and the sensitive areas. Whilst the council is a landlocked district, it is important for us to partake in the consultation and issue response, members. We're a key stakeholder in the renewable policy area. The district's a major contributor to renewable energy, primarily through wind energy resources and wind farms. And we've for some time then requested that there be a diversification and not a sort of over-reliance on onshore renewable energy. So the draft response then, members, is set out in Appendix 1, basically in broad terms welcomes the intention to diversify and build offshore energy. It also recommends that the council supports the consultation and the updated action plan, as it broadly aligns with the vision, objectives and policies within the plan strategy, and also the climate change and sustainable development strategy and action plan. As I say, whilst the proposals are unlikely to have any direct impacts on the district, given their location, there is the potential for indirect impacts and also positive benefits. So there's a number of sort of suggestions set out within the draft response, members. So in terms of next steps then, following the public consultation, then obviously DFE will consider further the refinement areas based on the best available data and evidence. So, Chair, the recommendation then is that we agree the draft response set out in Appendix 1 and we submit that then within the consultation deadline. Thank you, Chair.
Thank you, Paul. Any comments, members? Mr. O'Reilly, go ahead, Tom.
Chair, I want to check something against renewable energy sort of provision, I suppose, insofar as creating electricity supply and then the grid not being able to take it. We have, I suppose, ample room to have wind farms in our district. And where do we sit in relation to then being able to provide for the likes of major energy consumers such as data centers or something of that nature to be able to be built close to those production points, so that instead of not having them being able to be fed through into the system because the system can't take a backfeed of electricity, that we could utilize that energy created in our own area for the benefit of our council area. And does our policies allow us to be able to make those exceptions in rural areas?
Yeah, so in terms of this current consultation, then we've sort of, within the draft response, I think we've set out some discussion around just the infrastructure and the infrastructural requirements then, you know, and ensuring that there's some form of a joined up approach. So that's set out, it's an issue that we're raising. I think in terms of infrastructure, I think there's just a general acknowledgement by NIE that the infrastructure doesn't work, and a lot of the renewable sort of energy that's created then is lost. I think Sony has developed a plan which intends to, you know, over the course of the next 10 or 15 years, sort of replace and upgrade the infrastructure that's in place across not only our own district. I think there's a couple of proposals within our own district, but across Northern Ireland. So there's plans in place then to upgrade the infrastructure. In terms of our own policy framework then, that allows the flexibility, and we've had a couple of sort of seeing more of these now, battery energy storage systems along certain parts of the infrastructure where the energy is created. So yeah, it's I suppose the weaknesses and the limitations of the existing infrastructure is there, and it's acknowledged, and hopefully Sony's putting that in place to resolve it.
And well, I have every confidence in them to be able to do this. I'm not holding my breath. Funding being limited and all the rest of it. It's just to ensure that we have not just the ability for storage, but actual utilization of that energy at a point of source or as close to, so that instead of Mohammed going to the mountain comes to Mohammed as such, and that we could provide jobs and so forth within this council district. So, thank you. Oh, and Chair, could you indulge me in one other question that my brain is just thinking up as I go through things? Can we just go back, Chair, to the minerals SPGs? And can I ask, is this going to be retrospective to existing what's the word I'm looking for?
Mineral operation.
Yes, mineral operation, quarries. That's the word. That was the word I'm looking for.
Yeah, so the policy will apply to existing applications that are live in the system, but it won't apply retrospectively to developments that's already approved. We have no scope to review those. It's only live applications that's within the system or new applications coming forward.
Which would include extensions to existing. Yes. And would the policy then apply only to the area of extension, not the full site? Okay.
So when we have an application, so if it's an extension to an existing quarry, what the bond really does is cover the restoration. So the restoration will be the restoration of the extension that we'll be considering as part of that application. So the bond will only cover that extended area. I think we would have no scope to review the merits of the previous approval and the principle of that. Now there'll be some overlap to an extent, I would say, where there's extensions, but in general, that'll be the approach.
Okay. Any further comments, members? On that, can I have a proposal second to note? Proposed Councillor O'Reilly, thank you, Tom. And seconded Councillor Irvine, thank you, Robert. And we're moving then to item 12, to consider the quarterly update on live planning caseload report. Order 3 on this yourself, Sinead. Thank you.
Thank you, Chair. So this, as Chair said, is one of our quarterly reports. So this is quarter 3 in terms of live caseload for October, November and December 24-25. And members will note that there's a subsequent paper that's coming up on the agenda, which we'll probably get into a lot more detail, but this one's just looking at the live caseload. So the table then within the report sets out the total applications received and then the live planning caseload. And that provides information in terms of the length of time that's in the system. And then that table provides information looking back then comparatively at the previous quarter in the previous year and the one previous. So in quarter 3 then in 24-25, a total of 185 applications were received. And I suppose just worth noting then that marks a decrease of 32 applications compared to quarter 2 in the same year. And then in comparison to the same quarter in the previous year, there were 180 applications received. So that was an increase of 5%. At the end of quarter 3, the planning system had 346 live applications, and that represents a decrease of 7 applications compared to quarter 2 in the same year, which had 353, and then also a reduction from 394 applications, which was in quarter 3 of the previous year period. And members will then note that there were 233 applications in the system less than 6 months old. And then the detail of that live caseload then is set out at the table at section 2.5 of the report. So it's recommended the Council notes the report on quarterly live applications for quarter 3 of 24-25.
Councillor McLaughlin. John, go ahead.
Chair, and I propose to note this recommendation. I also have a proposal. In further reports, could we maybe have an additional line put in so that those cases which are specifically being delayed by NIEA and associated problems around partner agencies, but in particular NIA, are highlighted, because that, I'm sure, is the main burden and the main cause of our problems, and I'm sure Councillor O'Reilly will come in and back me on that.
Go ahead, Paul. Go ahead, Paul.
Happy enough, Chair. Look, members, I think we have just received a data set in relation to consultee performance from the Department for Infrastructure. So I think we've just reviewed that and analysed it. I think there's some accuracy issues with it, but I think there would be an intention in due course to bring an actual comprehensive report on consultee performance, setting out the numbers of consultations, the responses that's been on time, outside of time, how many weeks. So we bring that as a standalone report rather than embedded within the actual quarterly performance reports, if members were content. That'll actually set out on a spreadsheet all the detail, the very specific detail about numbers and when they've responded, how many weeks, their average processing times and all. So look, it's just a suggestion.
Councillor Irvine, go ahead.
Yeah, well, I would echo, I think, what Tom was going to say along with John. I have a slightly different query. One, as we say in the next report, we're performing very well. We've hit all our 3 statutory targets, and we're actually approving 97%, so we're actually top of the 11 councils. My question is, and we don't get it that often, your staffing levels, are they adequate for all the workload going forward, bearing in mind that we're now in sort of the second stage of the LDP, local policies plans, and we've had a brief discussion in regard to populating that section of work. I mean, it's just a thought. At some stage, maybe if you could bring it to the committee, just with regard to your adequacy of the staff coming forward, because I know we see it, we do the estimates process, but I think here it would be useful to know if it's okay, in that we're bringing in pre-application discussions as well as an offer to our clients, which is time consuming as well, but it takes up time at the early part and alleviates a bit of time going through the application. So it would just be useful to know if you're under any stress or strain, and if there's anything we as a committee could help you with. Thank you.
Oliver or Sinead, have you responded to that?
Thank you, Chair. Councillor Irvine, happy that we could come back on that. So it's like you say, obviously, at the estimates process, that's when we would be setting our budget, and that would include the salaries for our staff and complement. I suppose as we can see, the staff are working really hard. We're meeting, as you say, we're meeting all our targets, but very mindful that we have a lot of work still to complete in our LDP and the process around that. And certainly that's something that Paul and the team would be looking at, I suppose, staff and then within in terms of how we complement, but we can certainly come back on that.
Okay, Councillor O'Reilly, Tom.
Thank you, Chair. And it's not because we have any visitors sitting behind me here. I would be saying this anyway, we have an excellent planning department, and the figures bear that out, the work that is undertaken. But moreover, it's also bore out by the fact that as planning members, we make suggestions and tweaks to the system that hopefully can improve it. And we've seen the example of one there today where the agent was able to have his presentation, go through it and deliver it seamlessly at his own speed, which I think improved the way that we interact with the agents and the applicants. Then, I suppose, taking on the various training and so forth that we do gives everybody, both members and the agents, an opportunity to be on the one page and to hopefully front load applications and put in the proper information that allows us to make timely decisions. And I suppose that brings us on to the live planning files and the number of applications that, particularly over 12 months, that are in the system, 80 there and 33 between 6 months and 12. We're up over 100 applications there. And a bit like John, I'm interested to know what outside the agencies are holding that number of applications within the system. And while I would welcome the Pacific detailed report that you have got once you do your analysis on that report provided, that's a one-off snapshot of where we are. Whereas I would concur with John that if we had an extra line within the monthly report, it gives us a way to, as far as we can, real-time track what agencies are putting us under pressure. And at the end of the day, the agencies sit in the background, and it all comes down to when the reports are produced, which councils are holding applications in the system longer than others. It doesn't necessarily delve into the reasons behind, and we take the blame for those. So I think it's incumbent upon ourselves to get those detailed reports. That's fair enough, and we can then sort of reply back to them. But we need to build and be aware and track continuously where we see blockages within the system, not alone on the outside agencies, but if there is any others, Chair. So I suppose, for the likes of anything that maybe we set a bench where there is a particular time limit and that we get a green or a green, amber, red system that gives us an easily trackable system on our applications. But Chair, if John's happy enough as that general, I'm happy to second that.
Thank you, Tom. And we have Paul first, or Sinead?
I was just Just Chair, if you don't mind, I was only just going to make an observation, just that the report's quarterly, as members note, and it's obviously behind time insofar as we're looking at the previous quarter. So whatever we bring, things may have moved on then at the point that we were presenting it to committees, just to note that.
Paul, have you a comment there?
Yeah, thank you, Chair. I suppose, members, it's just, that's something that we would raise at the regional planning improvement work, it's just the challenges around the consultees, and there is the consultee forum then that's set up to try and improve that performance, and I think there is maybe some green shoots and some interventions to try and address that, and I suppose times there's over consultation from the planning authorities as well, which causes an issue with specific consultees. So I suppose so there's lots of work going on trying to improve that, and certainly one of the new interventions that's been brought in and we've agreed through the heads of plan was actually a prioritisation system with NIA, and we've actually managed to get 3 council applications prioritised through the consultation process. It was subject to funding, so there is work going on and there's progress being made. So that's one point. I think the second point, trying to break down applications, so if there's a pot of 80 applications which are over a year old, like we, as part of our own improvement programme, we're focusing on those older applications. We're trying to move them through the system. Some issues with them in terms of Section 76 agreements, affordable housing, those long-standing applications, working through details, and also they'll not all be the responsibility of consultees. But I think trying to break it down might not actually give you an accurate picture, because we could bring you a report that says, well, this application, this specific application, is currently waiting on information being submitted by the agent. But in reality, that might have been because NIA is 4 months out of date with their consultation. But the current status of the application that we bring forward, in that report, mightn't actually give you a true picture of what their performance is actually like, or what has held the application up. I think the actual specific report then that sets out what the consultee's performance is, how many consultations have been issued to them, the length of time that it's taken them, and it's specific to our district. It's not a Northern Ireland report. That'll set out exactly, only 10% have came back on time. That's a significant issue for us, or only 20% have came back on time. And then it'll set out actually in weeks, that if there's been a delay or an issue, that it's actually been, 30 weeks or 40 weeks or 50 weeks beyond the target, which again is a significant issue. So I think that's going to provide the granular detail that members need. But happy to take it away and have a look at it, see what we can produce, and see if it's any value then. And if it's no value, then we can forget about it. If it's a value, then we can keep bringing it forward and include it in the report. So open to suggestions.
Hey, thanks, Chair. Thanks, Paul. Yeah, I just go back to that I'm not so sure how many times we're expecting to get that granular level report from the outside agencies, so that maybe snapshots in time. But I would certainly challenge back a little bit here that if we are looking for that report, that we don't get a agent awaiting information, sort of status, because that really doesn't tell us anything. We could put them all down to the agent awaiting thing. So somebody needs to look behind which piece of information we should be able to interrogate the system a little bit better than agent waiting for information, and give us something in more specific. But I take your point on board that if we take a look at it and sort of find that it's workable, then that's of our value. There's no point in producing another line just for the sake of having it if it's not giving us anything useful that we can action. Because the whole point, and I take it in the premise of what John has proposed and seconded by myself, that the value in putting in another line there gives us a trackable, so that in 6 months and 12 months we can go back in front of the granular report being produced and sort of say, well, this really hasn't changed, or there is specific applications that you're not getting to, or whatever the case may be. But unless we have, itemized sort of understanding of why the long-termers are sitting there, which, in the overall context, isn't that many of them. So I appreciate there's a bit extra work or whatever, but we should be able to interrogate it a little. Thank you.
Okay, Tom, thank you. Moving on then to item 13, to consider the report on the plan and performance statistics for the third quarter, and then that's yourself, Paul.
Thank you, Chair. So, members, this is paper J, and it's quarter 3 then, plan and performance statistical report, which has been issued by DFI Stats Branch. So, I suppose, members, just before we sort of get into the detail of it, I think it is a positive report, positive in terms of performance, and certainly a reflection of all the work that's been done in the planning improvement programme locally. I think those interventions that we've made streamlined the process, but as Councillor Riley already sort of said, there's a lot of those actual practical improvements that we've made, providing members with a presentation, bringing our speakers up front, using the presentation, using the clickers. It's a more professional approach, certainly better user experience for the customers that come before us, members. So I think it's a credit to all the work that's been done in this chamber, and also all the good work that's been done by Darren and Lavina and all the staff, and all the hard work day in, day out in issuing these decisions. So basically in terms of the report then, members, this deals with the third quarter, which is October, November and December 24 to 25. And there's various appendices set out there within the press release, 1 to 4. So, Fermanagh and Omagh District Council, then we've met all 3 statutory performance targets for the year to date. Total of 185 applications were received during the quarter, an increase of 5 applications compared to the figure reported for Q3 in the previous year. And during Q3, 185 applications were decided as well, which is an increase from the previous quarter, quarter 2 of 31 applications, and 15 more than the total from quarter 3 the previous year. So it's good to see the decisions issuing increasing. That's a good positive sign. The approval rate then, applications within the district's 97.8% in Q3, and that's the highest across all 11 councils, compared to the Northern Ireland average of 94.7%. And again, I think that's a sort of reflection of all the work that's done through our PAD processes, through our validation checklist, getting the quality information submitted, the quality submissions. At the end of quarter 3, then there were 346 live planning application files, and Sinead's ready to give a breakdown of those, so I'm not going to go into those in much detail. And just really from here, members, just to pull out a couple of key points in terms of our major applications. Year to date then is 24.2 weeks, which was well within the target. In terms of our local applications, then year to date it's 9.6 weeks. So I think it's a really significant achievement to get that under 10 weeks. Certainly in my time, I haven't seen performance under 10 weeks. So is really good. Terms enforcement again, members, year to date, we're sitting at 28.6 weeks and the target's 39. So again, well within the performance target. So reports essentially, for noting, Chair, there's a few additional non-statutory performance indicators, but I think overall it's a real good reflection on all the work that's been done. Thank you, Chair.
Okay. Well, I suppose as Chair, I have to offer my congratulations to yourself, Paul, and Sinead and the team, and it's great to see the figures, I'm sure. Councillor Riley will add to that.
Yeah, just to concur, Chair, and congratulations to everybody involved. I think it's at the end of the day, we keep in focus an end user, and that's our applicants that are coming through, and we are trying to provide the best service that we can. We continuously try to improve how we do things here, both within the system generally and within the committee when applications get to that. And I think that the figures reflect the professionalism that goes on day to day behind the scenes, as it were, that maybe not everybody out there is privy to, only if you have an application in the system. And notwithstanding that, we're continuously looking to improve. So certainly want to offer my congratulations to all the staff. Thank you, Chair.
Thank you, Tom. Any further comments there, members? Okay, could I have a proposer and a second then to note that report? Proposed Councillor Irvine and seconded Councillor Mahon. Thank you, David and Robert. Item 14, we have no urgent or relevant business. We move on then to item 15. I have it marked as correspondence. It's over to yourself, Sinead, please.
Thank you, Chair. So we have 3 items of correspondence today, and if you're content, Chair, I'm going to take item 1 and 3 together because they're related. So the first item of correspondence there relates to Taddymoyle Wind Farm, and members will recall that we had written to the Minister in relation to that and queries around just the Section 26 determination and our views, setting those out previously and again in the most recent letter. So the letter then that has come back from the Minister is really advising that in the correspondence of 2024, they had set out, September 24, that is, the Department had set out their position on that. They've also reminded us that statutory provision to screen proposed applications determine whether their regional significance is applicable only to the Department, and the Council and applicant would be informed of the Department's decision in due course. So before I deal maybe with the rest of that particular response, then I want to just look at item 3 then in terms of correspondence, because that has just come into us today and then relates directly to this. So we received then correspondence today specifically in relation then to the Taddymoyle wind farm. So that came in and it has directed us to Section 26 of the Planning Act and then encloses the notice then that has been served on the planning applicant. And that directs then the applicant that it states that having considered the information provided, the Department is of the opinion the development would, if carried out, be of significance to the whole or substantial part of Northern Ireland. And then in accordance with Section 26 of the Act, the Department notifies the applicant that the development proposed is development to which Section 26 applies, and then any application would be made to the Department. So that's the Department confirming then that that application would be with them for determination. So those 2 pieces of correspondence are for noting, but I'm just going to go back then to the end of that letter just for information, which was item 1 of the correspondence, just to note that the review of the planning regulations is ongoing. The Minister or the Private Secretary of the Minister is advised following the public consultation in 2024 with the aim to ensure the regulations are practical and appropriate to support the current and future development trends, and plan officials continue to review that and analyse information from the consultation.
Thank you, Sinead. Could I have a proposer to note? Councillor Irvine, bear with me. Go ahead, Councillor Irvine.
Yeah, I'm happy to note, but I'm disappointed basically at the level. We're coming down to 10 turbines, and 10 turbines essentially, probably because now of the gigawatt output is reaching the capacity limit that the threshold has been set at. I mean, this really is delving into minutiae from the department, and we have the officials here. Really, somebody needs to get their head out of the sand and look at where the things are going around this. I would have presumed a regionally significant wind farm if we take out the megawatt capacity, because that actually is a separate issue, I think, to the turbine issue. The pylons and the turbines actually create more of a visual impact upon the land because of the height that they're at and the clustering they're at, rather than the output capacity. So I think the criterion that is being used by the department is back to front. I would use a vernacular here, but there are members of the department, and I won't go down into the vernacular basically, and I'm sure we know what the vernacular means. It really needs to come up And we, as well as probably Mid-Ulster and a wee bit of Derry City and Strabane, are the ones most affected by wind energy, basically. And it really is affecting us. I believe we have a very effective policy contained within our plan strategy, and we should be allowed to actually interact that. And the other thing is, it is well shown, I think, from the performance to date by our officers that we can deal properly with major applications. I hazard to think if the department can determine as quickly. So I'll throw it back to that. And that's not trying to raise an argument between officials here, but it's just from our point of view, a statement of fact. So I'm happy to propose noting. Thank you.
And just to remind you, Councillor Irvine, they're here in the observation role today. Go ahead, Paul.
Thank you, Chair. I suppose, members, it is hugely disappointing. I actually thought that when the scheme was reduced that it would come back to a local level. I think in reality the application only has implications at a local level. It doesn't have regional implications. So hugely disappointing. In terms of review of the management regulations and the thresholds, I think there will be some positive news coming out of that just in the work that I've been doing in the Planning Improvement Programme. And I think shortly, potentially in the next few months, then there'll be an intention at DFI to sort of give a sight of what the new thresholds might look like to make sure that they're fit for purpose going forward. So I think the wheels are in motion through the work that we've done and the lobbying that we've done, that they will get changed. But hugely disappointing in the here and now that this application will come back to us. Thank you, Chair.
Thank you, Paul. And Councillor O'Reilly, Tom?
Chair, absolutely disappointing that despite all of our lobbying here, that sense hasn't prevailed. I go so far as to say that, you know, as Robert has outlined, regionally sort of has come down to very small now at this stage, and output and visual look are being sort of notwithstanding what Paul's saying there of a potential look at things, but are getting a little bit conflated from a department point of view. And I think the ability and professionalism within the local, which after all, to a greater or lesser degree, sometimes a lesser degree now, was why planning was devolved to the local authorities, was the ability to make decisions for their local areas, and only at regionally significant level were they to be taken at department level. And I think there's certainly a blurring of that line going on there, and I think that we need to continue in whatever way that we can to not be distracted by this decision, but to continue to lobby for change there.
Happy enough to second the opening.
I am indeed, Chair.
Tom, thank you. So moving on then, there's a third item, Sinead, reference telephones.
Thank you, Chair. So this is, it's item 2 then in terms of your correspondence under other. So this is correspondence then from Department for Communities, and this is setting out recent listings in terms of 8 structures, which are telephone kiosk structures within the district. And members will recall that we had discussed the response to those previously at a previous committee. So you'll note now that they're confirming to us that those structures have now been listed have now been included as structures as being listed.
Thank you, Sinead. Councillor Mahan, go ahead, David.
Thank you, Chairman, and thank you, Sinead. I'm not sure if maybe I missed that previous discussion, but I noticed some of these are, you know, really joint-hill third-party properties. What sort of risk do they have if they want to do works to their own property or demolish or build, or I'd be concerned about that. And who is going to maintain these structures if something goes wrong with them as well? Get some clarity on that.
Go ahead, Paul.
Okay, Chair. So, members, that report was dealt with, I think, last month in confidential business towards the end of the meeting. So we had raised concerns with the listing of the structures. Now they have Department for Communities, HEDs obviously went ahead now and listed those structures. So they are listed. that has significant implications in terms of works that can be done. So there's a definition of listed building, and it includes the curtilage of the building. So within that curtilage, any work that's required will need a consent. That's even for minor works that wouldn't necessarily need planning permission. So it has huge implications for the landowner. I understand as part of the HED's process that they would have engaged with the landowner. So they will obviously know the implications of this. I think, I'm not an expert now, but I think that the landowner will be responsible for the upkeep of the structures, however that might be.
Okay, thank you. Happy.
Yeah, I'd second noting what the observation is. We know how restrictive any works, even of a minor nature, can be to listed buildings or listed structures, I should say, not listed buildings, and that they have to be sympathetic and authentic. I think if you're going to do anything, a lot of these kiosks had substantial damage done to them, glass smashed and everything like that. The glass is going to be replaced. It's going to be an issue trying to get authentic glass. I just think it's madness. Thanks. Bye.
Okay, Councillor. And Councillor O'Reilly, Tom.
Chair, can you maybe, Paul, just refresh my memory on listing of buildings generally? In fact, I had a query on that for the workhouse in Lisnaskea this morning, and I wasn't quite sure, but my understanding is that the department lists and notify us. We don't as a council have a say in whether they are listed or not listed? And is that similar to the work that then was done on these kiosks? Somebody has taken a decision, rightly or wrongly, somewhere down the line that these are worth being listed, and the implications, there's no sort of leeway left against these kiosks when it's a building of substantial nature. It all comes with the same restrictions. Would I be correct in saying that?
Yeah, and I suppose the detail would have been in the previous report, just around the process. We as a council will be consulted on the intention to list. And that's what we had sort of responded last month to say that we didn't feel that the structures were of a merit, because it's only structures which are special, essentially outstanding, that should be listed. We didn't feel that they had met those tests. So we as a council, we are consulted as part of the process. We have fed back those comments, but it's ultimately HED through their own processing who designates what are the listed buildings and adds them to the listed, the list of listed buildings. So they've went ahead actually quite quickly now and designated those as listed buildings.
And Chair, is there, I suppose it's a waste of time, but, it is this continuous fight about local government and the relevance of local government and the importance of local government and the whole concept of the devolving of powers to a local government to make decisions for their local area. Should we not be challenging in some way back against this idea that we're only treated as a consultee? It doesn't matter. I don't want to use the analogy, Chair, but it sort of springs to mind of many years ago sitting in the chamber and we were consulted by the planning department on planning applications. But if they took the decision to go ahead and do whatever, they went ahead and did whatever, I'm not sure if that's the appropriate one to use or not, but it did jump to mind. And we did get a change, Chair, where local government started making local decisions in partnership with professional people. So you know, maybe we need to embed a HED person within local government in each area or something like that. But the decision making seems to be remote. That's what I would say, and not very responsive to the wishes of the local people.
Paul, you wish to make a final comment?
Yeah, it's really just to say the the legislative provision has that responsibility with DFC HED at present. I think within our report last month, we sort of acknowledged our limitations because it is a very specialist and expert area. That whole heritage and the professional qualifications and the people that's involved in taking that forward. So certainly I would have no expertise to challenge that, although we did in principle raise issues, so.
Okay. That's everyone finished. I think that's actually the agenda complete. Thank you all for your attendance, and thanks to Rosemary and Aileen for your attendance. I hope you found it some benefit to yourselves. Not like Robert to try and get an opportunity to have a direct jibe at the department, but fair play to him for trying anyway. So, so safe home, Slano, will you? Thanks very much for your attendance. Thank you, members. Bernard, good luck.